Lord, order has complied, my lord. The petitioner has received, my lord, amount.
Applied. Judgment and order dated.
Suspend.
Judgment and order dated.
I don't know.
Okay. When the matter reaches next.
One file an affidavit in opposition, so we need some time to file the reply.
They are rejected. You know, you can't seek an adjournment filing reply. At this hour.
Yesterday they had filed.
We'll see when the matter reaches.
My lord, item number 42. My lord,
Yes.
it will be listed after 2 weeks. My lord. I will be some person difficult.
Mr. Miss, your name?
Spot
Ms. Esbar Potra Gauhati seeks for an accommodation. This is the matter of 4 weeks.
of this.
I'd like to mention, that the matter may be listed on Monday, madam. It's a motion matter. It was filed on first of
Motion.
May it please your lordship, I beg to mention for listing one contempt matter on tomorrow, lordship, for withdrawal.
Okay, sir, Lordship, I beg to mention item number 36. Lordship, yesterday I submitted the adjournment slip, taking the consent from the other side. I am for respondent number 9. Lordship, the learned counsel, she is not present since yesterday. She is not present, the learned counsel for this matter. I am for respondent number 9. So yesterday I filed the adjournment slip, taking the consent from the petitioner.
What is the matter about? Is
Lordship,
there any interim order?
This is that matter.
That one.
Friday,
That one.
market matter.
The file affidavit in opposition, they will
No, we filed it on the last time, but it was not on record.
The request of the council for respondent number 9. Interim order, no interim. Matter stands adjourned to be listed. Anybody has any objection, the other side?
Already taking signature from the other side.
Be listed after 4 weeks.
Lodge.
I would like to mention item number 15, my lord. Item number 15, my lord. My lord, in this matter, my lord,
Mr. Doctor, wasn't the status quo order there in this case? If I remember correctly.
Status quo earlier.
No, in this case, there was a status quo for which there was somebody filed an application for contempt.
Yes.
I dismissed it.
The earlier matter.
So in this matter, I think there is a status quo. No, when the matter reaches cancelled.
my lord, item number 15, my lord. Here in this matter, my lord, I have to file, my lord, an alia, my lord, implementing 5 of the parties, 5 parties to be included in this case, my lord. So
It
my
has
lord,
not
2
come.
weeks- Not yet, my lord. I have not annexed, included that 5 as parties in this case, my lord.
What do you want?
I want to implement them, my lord. In the I beg to mention that, my lord, I need
You want an
2
accommodation.
2 weeks time, my lord.
At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after 4 weeks.
My lord, item number 3, we have filed an additional affidavit. I mean, finally allowed to bring it on a record. It comes.
May I please your lordship? Lordship, I beg to mention item number 1. As my senior could not come to the court due to some personal issues.
What is the matter about?
It's about actually, I'm so sorry, lordship. I'm new to this chamber, so little knowledge about this matter.
You wait when the matter reaches.
I don't 56, I've checked, my lord. Status quo is there.
I remember.
Yes.
I don't forget. No. So therefore, prayer is rejected. We will look at the time. Yes, what is this? Why the petitioner is not appearing in this matter for all this while? Last time also when the matter is there. What is the case about, Ochia?
Lordship, actually, my senior keep Bhuya, she
Mr. Doctor, what is the case?
My lord. Something relates to fishery. They want, my lord, one fishery, my lord, as public fishery.
in Morigaon district, my lord, there is a fishery, and according to the petitioner, my lord, the Gao Panchayat president and secretary, they are not allowing the petitioners and other persons to fishing there. That is their case.
Counsel appearing on behalf of the petitioner seeks for an accommodation. It is also seen that on the earlier occasion also, the counsel for the petitioner was not present. It seems that the petitioner has no urgency in the instant writ petition. And accordingly, let the writ petition only be listed upon an application being filed before the registry by the counsel for the petitioner. What is this?
Well, I'm challenging the order at page 57, my lord. Whereby, my lord, they have
Lordship, the order at page 57 has been withdrawn. My lord.
Yes.
Lordship, this order, the distributorship had been withdrawn, your lordship.
Huh?
That order has been withdrawn by the Supreme Excise. The order which the petitioner can put to challenge.
Order challenge has been withdrawn.
Page 57.
Where is the 26th March order?
my lord, page 57.
57.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent.
Excise
number
department.
1 to 5. The present petition has been filed assailing the order dated 26/3/2026, passed by the Superintendent of Excise in Supia, whereby the license of the petition, the renewal proposal of the licenses of the petition were not taken into consideration in view of an order number 389586/6 dated 18/11/2025 of the Commissioner of Excise Assam. Mr. R. Gogoi appearing on behalf of the respondent numbers 1 to 5 I submitted that the said order dated 26th of March of 2026, 26th of March 2026, have been withdrawn by the Superintendent of Excise by another order dated 28th of April 2026. The said order dated 28th of April 2026 is kept on record and marked with the letter X. Taking into account the above, nothing further remains in the instant petition. Accordingly, the petition stands closed.
All right, no.
Maybe it works. My lord, a petitioner is a distributorship of a LPG distributor, my lord. And by way page 21.
Yes, tell me what is your case?
My lord, a petitioner herein is the LPG distributor, my lord.
You are a
LPG distributor.
Ah.
At page 21 is the impugn order, my lord. Issued by the District Commissioner, Kamrup Metropolitan District. Page 21, the petition.
then
My lord, without any notice, my lord, the order was issued on the basis of some reports and complaints. The first line lordship will find,
you are put under suspension.
my lord.
No, the notice will issue subsequently.
My lord,
This will
after-
be notice will be issued under 15(2) later on. What is the cause of action of?
my lord, the findings in this order are without any notice, my lord.
What is the, where is the, show me where a
My lord,
notice is required for a suspension.
For suspension or for cancellation notices. required.
Cancellation is
Yes,
there. Here it is a case of suspension.
yes, my lord, as per,
Withdraw with liberty to again approach when you are you are cancelled.
my lord, they have already taken action against us, my lord.
They will issue notice. Have you been issued notice or not?
It will be issued.
No, no, they have to do it within 90 days. If they
Yes.
don't do it, come again. We are here waiting for you.
My lord, already the IOCL authorities has taken action against us, my lord, on the basis of this order, my lord.
So,
My lord, kindly, my lord,
we cannot stay this order.
my lord, yes, my lord, but
What
earlier,
action have they taken? IOCL?
additional affidavit filed by us, my lord, on my lord.
No, I am
7/4,
asking you what
2020.
action they have taken.
Yes, my lord, that I'll take the order to that, my lord.
Ah.
Additional affidavit filed on 7/4/2026. Lordship will find it page 29. This is the email, my lord, on 6th April. We received that on 10/20.
So what is wrong? IOCL, now you are suspended. You are LPG.
LPG.
There is a dearth of LPG. So therefore they'll take over the LPG and sell it, distribute it to somebody else. Yes. What will happen to those people? When your license is suspended, you cannot distribute.
Yes.
So what will happen to those customers? Give me a good reason.
My lord,
You are a distributor of IOCL. So when you are a distributor, it is actually the duty of the IOCL to send it to the customer. You are just the link.
yes, sir.
Now the link is being suspended. So they have to now divert it to somebody else. Unless you have a very strong case, yes, suspension under no circumstances can be given. That is a different thing. But why should this court interfere at this stage when they have some preliminary things? Yes, if you don't have a case, we'll look into
My
it.
lord, as per the emails, my lord, sent by them,
Who?
IOCL authorities, it amounts to cancellation, man.
Where?
Page 23, or repetition, man.
Page 23. In reference to immediate effect due to contravention of various provisions of the one to suspend or cancel the license we apply and in the interest of esteemed consumers of the license to stop the services in the so it's not a cancellation. And we'll take it. It is not a cancellation. This is a temporary arrangement till that the suspension, huh?
Subsequent because they clarified, it's an interim arrangement till what?
Where is that?
Subsequently, after this. petition is filed.
Have you have a copy of it?
I had instructed the same, they had clarified. In any case, because we have to terminate specifically, we have to issue an order of termination. Separate. That kind of thing, we have to make termination.
Milord, basically what we would like to ask Milord, they have a power of suspension that we are not disputing. If it is below 90 days, then they can, Milord, without anything, they can claim. But Milord, if we look at the overall circumstance, what appears, Milord, in my humble submission is that they have finally taken a decision without any so-called notes. Now,
No,
for example, if your lordship should kindly have a look at the order passed by the Deputy Commissioner, Milord, at
Yes.
page 21.
Yeah.
Based on this type of allegation, Milord, an action can be taken. Is it so subjective? Please come to page 21. Falsified delivery record by showing LPG cylinder as delivered in official portal. Manipulated booking.
Mr. Chaudhary, on top it has been prima facie established. Prima facie.
No, Milord, what I'm saying is, if I'm supposed to reply to this, I must at least be told that X was the consumer who has booked a cylinder. You have not booked it. And in the name of X, you have given it to Y. Something like a, Milord, I'm relying.
No, for that,
Yes.
a show cause notice will be issued.
No, show cause, no, Milord. Therefore, no, what I'm trying to submit, Milord, based on this, Milord, can it be so subjective, Milord? There has to be some objective material based on which this subjective satisfaction can be derived in. Now that I am guilty of X, Y, Z, that is subjective. But Milord, the materials must be objective. Which are the materials, Milord? Milord, therefore,
For the purpose of suspension, that is not required. For the purpose of a show cause, that is required.
Milord, my humble submission is, even for the purpose of suspension, Milord, since it is an exercise of subjective jurisdiction, Milord, satisfaction, Milord, it is always amenable to a 226 proceeding. For example, if your lordship kindly takes note of the income tax and all other cases, where the Supreme Court has said, when any action is taken based on subjective satisfaction, then they are supposed to place the record based on which this satisfaction was derived. That they are bound to. The office of the Deputy Commissioner is bound to place before your lordships in a certiorari jurisdiction, Milord, based on what materials they formed his opinion. Where is
You
those?
want to challenge it? There is
No, we have
problem.
challenged it, Milord.
No, only you can very well challenge it. We'll have it after 3 months, and thereupon let him in the meantime complete it. We'll then see.
No, Milord. My only
The
problem
question of
is.
stay is not there. The question of stay of this order is not there.
No, Lord, I'm not. Prima facie, what I'm trying to submit is, here is a case, purportedly there are certain allegations against me, based on which some action has been taken. I don't even know what is the allegation. Can this be permitted?
No. Allegation is there for which you are not here to file a reply to this.
No, my Lord,
The allegations will be there.
My
in
Lord,
the show cause notice.
my Lord, I'm relying on a judgment of the Supreme Court, my Lord. 2009-10 SCC, page 32. Please have this judgment, my Lord. Please have paragraph 24 and 25. My Lord, subjectivity cannot be stretched so much. Para 24 and 25.
Yes. Because sorry, you are not challenging a show cause notice.
I am not on that. Lordship will kindly appreciate one
Only a Supreme Court judgment by which it says that for the purpose of suspension, there has to be a show cause.
No, my lord, I'm not saying that. What I'm saying is, going by the language of the order, this is not a very clear cut statutory provision. Please have that, my lord, that provision. Please have para 11, my lord. For the present, I am against the suspension.
Yes.
11, my lord. Suspension and cancellation of license. Ase? If any licensee or his agent or servant or any other person has something wrong, my lord, on behalf contravention of any of the terms and conditions of the license, then without prejudice in any other prejudice to any other action that may be taken against him under the Essential Commodities Act, his license may be cancelled and order in writing of the licensing authority, and entry will be made in this license relating to such suspension or cancellation. No order of cancellation shall be made under this clause unless the licensee has been given a reasonable opportunity of stating his case against the proposed cancellation, but during pendency or in contemplation of the proceedings of the cancellation of license, the license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of the stating his case. Such suspension shall be limited only to those trade articles regarding which contravention has been made by the licensee. Therefore, what I understand in my humble submission is, my lord, power of suspension is there. But power of suspension cannot be exercised in thin air. Power of suspension must be based on some objective material. So when a citizen lays a challenge to an exercise of power which is based on subjective satisfaction, my lord, my humble understanding of the law is, then, my lord, the authority is bound to produce the record before the lordships. Then lordships will examine whether power was properly exercised. And in the process, in an appropriate case, where your lordships, considering the urgency of the matter, may also consider passing an appropriate interim order. So I'm not praying for an interim order today. What I'm saying is, my lord, let them produce the record.
Sorry, on a lighter note, in respect to those judgments, those APSC matters, I categorically say the question of suspension of a stay of a suspension is absolutely cannot be done.
No, my lord, suspension is not a punishment. Therefore, normally it is not interfered with that. I am also aware of. But question is, my lord,
yes,
the severity and the consequences which ensue. That is, my lord, at least the coordinate bench the other day protected us from the other aspects, my lord. At least that they will not, because they intended they issued 2 emails. By one email, we are asked to, my lord, keep everything in ready so that they may take over. That part has been stayed. So whole idea was, my lord, since it is an essential commodity.
If that stay,
Yes, it is there, my lord.
But I think we should vacate that stay.
Huh?
There is no stay. Having regard
No.
to so and so, it is observed
Yes.
there shall not be any coercive action in terms of.
Yes, no coercive action.
But the fact remains,
Yes.
if you are having you are the LPG distributor. Now the LPG, the containers of the LPG would be with you.
No, the problem is there is an interlocking system. There is a coordination between the Millard Oil Company and the Office of the Deputy Commissioner. Now our thing has been blocked because of the suspension.
Understood. But you cannot distribute.
No, my lord, from the oil company side, there is no restraint order
In view of the license
because of
being
the
suspended,
suspension
you
of the
cannot
license.
distribute.
Yes.
Now, at a time today where there is a scarcity of LPG, would it be proper on the part
Certainly,
of
my
the
lord.
school?
In that case, it is an essential commodity. They
an
can make
essential
alternative
commodity.
arrangement.
Otherwise, if the Iran-US war was not there, we would have considered this. But otherwise, it's to the end
Well,
of date.
Well, all that I'm praying for,
the consumers would be affected.
no, well, all that I'm praying for is, lordship will ask the Deputy Commissioners Council, my lord, to produce the record and to show to your lordship's prima facie.
Let them file affidavit if they.
No,
Let
my
them
lord,
file an
affidavit may take some time. Let them produce the record, my lord.
No, the
because
moment
end
you are
of-
saying, you are saying that there is this is based on a subjective satisfaction.
Yes,
Subjective satisfaction, then obviously he has to have the right to file an affidavit. That is the law, settled law. So without his affidavit,
either they
we
file an
cannot
affidavit
decide.
or they produce the records.
I have to give him an opportunity to file an affidavit.
Yes. Or
Without
lordship will-
affidavit, yes.
lordship will give a shorter period.
Yes, Mr. Chaudhary, I can do only one thing.
Yes,
I can have this matter within 15 or 20 days.
Yes.
Finish it off if I have it. But
Okay,
no stay business. And this order also, no coercive measures, you return those LPG distributors. And he says he's particularly mentioning, he's giving a statement, and I'm going to record it, that this is only an interim arrangement.
okay,
So if this is an interim arrangement, nothing to do with the cancellation
yes.
of your distributorship license, which is his submission, then I don't think you have any
Yes.
quarrel with him.
We are not taking that, we are not taking any course, we have reiterated it at page 52.
We don't have page 50.
The additional.
My file is limited to page 29.
That recording is.
No, there's no interim measure. I'm therefore modifying that order, earlier order, to the effect that you can very well take over that thing, but this taking over shall not in any manner, that I'll record that it is your, it's only an interim arrangement. Issue notice making it returnable on 19th of May 2026. Mr. Tina accepts notice on behalf of the respondent numbers 1, 2, 3,
120.
and Mr. N. Borua accepts notice on behalf of the respondent numbers 4, 5, and 6. Extra copies of the writ petition be served upon to them, to the learned counsels, during the course of the day. The petitioner herein, who is a distributor of the Indian Oil Corporation Limited, who is an LPG distributor of the Indian Oil Corporation Limited, is aggrieved by the action on the part of the respondent number 3 in issuing the order of suspension in terms with clause 15(1) of the Assam Trade Articles Licensing and Control Order 1982, 11(1), 15(1), no, 11. Read with the provisions of the Essential Commodities Act 1955. First, the resultant effect of such suspension of the petitioner's license by the respondent number 3 had led to the petitioner, led to an apprehension of the petitioner on account of certain emails being issued by the respondent number 4.
That kind permission, can I take it?
Respondent number 4 on account of that their distributorship license, the distributorship agreement with the Indian Oil Corporation would be cancelled. It is under such circumstances the present petition has been filed. First, the learned senior counsel, Mr. K. N. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted that the subjective satisfaction on the part of the authority to suspend the license has to be based upon materials And in absence of such materials, there cannot be the exercise of the power would be contrary to the provisions of law. The learned senior counsel therefore submitted that a perusal of the impugned order dated, what is the date? Dated 4th of April 2026 do not show that there were materials on the basis of which the respondent number 3 had arrived at, could have arrived at a subjective satisfaction. The learned senior counsel therefore submitted that the impugned order dated 4/4/2026 be stayed pending disposal of the incident with petition. The learned senior counsel also submitted that if the impugned order dated 4/4/2026 is not stayed, there is a strong likelihood that the respondent IOCL may cancel the distributorship agreement with the petitioner. First, it is the opinion of this court that as to whether there was a subjective satisfaction based upon materials available with the respondent number 3 can only be ascertained by giving an opportunity to the respondent number 3 to bring on record such documents, such materials, on the basis of which such subjective satisfaction was reached. Under such circumstances, it is the further opinion of this court that granting a stay to the suspension order would result in granting the final relief without giving an opportunity to the respondents to rebut to the allegations of the petitioner. Under such circumstances, this court is not inclined to pass any interim order of stay of the impugned order dated 4/4/2026. This court also cannot turn a blind eye to the fact that the petitioner is in the business of distributing essential commodities. And as such, the license, if is suspended for a long period, it would affect not only the petitioner, but also the Indian Oil Corporation and its consumers. Considering the above, this court directs the district commissioner to bring on record its stand by filing the affidavit on or before 12th of May 2026. 12th May, huh? First, this court further grants liberty to the petitioner to file reply thereagainst on or before 18th of May 2026. First, this court have also heard Mr. N. Burwa, the learned counsel appearing on behalf of the IOCL, who submitted that the emails which have been issued and have been challenged are temporary in nature and would not impact the distributorship license agreement entered into by and between the petitioner and the IOCL. For the purpose, the learned counsel appearing for the respondent IOCL further submitted that in the circumstance there is a requirement for cancellation, the same shall be done as per the distributorship agreement. Considering the above, it is therefore the opinion of this court that the apprehension on the petitioner appears to be misconceived insofar as cancellation of the distributorship agreement. Accordingly, this court is also not inclined to extend the interim directions so passed by this court on 7/4/2026. The registry shall list this matter on 19th of May 2026 at 2 p.m., on which date an attempt shall be made to dispose of the writ petition. Before parting, this court, however, finds it pertinent to observe that the pendency of the instant proceedings shall not bar the respondent number 3 to initiate the process for cancellation of the license if so advised by issuance of a show cause notice, taking into account the mandate of clause 11(2) of the Assam Trade Articles Licensing and Control Order 1980.
With item 36, they have taken an adjournment and there is an interim order till today only.
No, I have not granted it. I did not grant it.
Lordship.
You see, I remember that matter because that
The
contempt was filed.
cattle market.
So I remember. So both the sides said that there was no interim. Then I said there is an interim order. Then Mr. S. Dutta found that there is an interim order. So I rejected that prayer. So we will take up the matter when it.
Lordship. Okay.
What is this, Mr.?
Blacklisting order, my lord.
Huh?
Blacklisting. A debug.
But they are not following my judgment.
Yes, my lord. That Nestor judgment has not been followed.
Huh? Where
Neither
is my
that
judgment?
contact has been cancelled nor any department order has been
My
passed.
department order was passed prior to the judgment passed by your
But
lord.
why don't you take it properly? Where
The
is my judgment?
My lord, this is-
That is for so-called,
sir,
that is a
followed-
so-called proceeding.
This was followed in many cases, my lord, subsequent.
Huh?
This was followed in many cases, subsequent.
Please?
Yes.
Ah.
Para 43, the main, my lord, at page 30.
This order was passed when?
This order. 1411. Page 154.
Where is the date?
My lord, the date is next page. Last page.
And why you are approaching so late? We can't state.
We have approached the, my lord, the authorities,
We
my lord,
can't
because
state.
there was some miscommunication because we have supplied materials, but they have not.
Page 164.
154. 154.
164.
54.
And what is 164?
164 is, my lord, that we have submitted, my lord, the information that we have already supplied the goods, my lord. And, but they rejected it on the ground that no receipt has been produced, but challenge are there, my lord.
154.
154.
There's no date mentioned. Mister, where's the date of the order?
My lord, they have only mentioned here, my lord, 12 November 25, as of that.
Huh? There's no date.
156, my lord, they have, table is there, they are only date.
What date?
I don't know.
You don't have a date?
My lord, even,
Where?
but my lord, page 166 says, my lord. even
Page?
Page 166, because they filed one representation against the department order.
Ah.
Thereafter, a speaking order has been passed, so one.
Has
page
failed to produce
166,
any
second
admissible
paragraph says,
evidence corrected. The
Department order number
pre-validation of
27.
no verifiable materials have been brought once, so in view of that and in view of 1411.
1411.
But probably it was there in page 155, digitally signed by there, some portion have been cut. My lord. So probably there,
What?
their date was there, page 155, my lord. 14/11/2025.
Oh, this person did not come to Mr. Sahewala and directly filed the representation.
Yes.
Huh?
No, because there was my lord, some miscommunication because we already supplied my lord goods. My lord, but the district authority is not.
Okay. We do one thing, we issue notice, mostly. We issue notice as he has come so late. We issue notice and in the meantime, you take a decision. Taking into account this judgment.
Yes, my lord, your lordship may indicate that.
Because why I'm saying so, it looks nice
Yes, my lord.
on the part of this court also to keep on doing it. In fact, there was another matter of Mr. B.D. Das.
Yes, my lord.
After this Nestor, he came up. I did not,
They
but
took a decision.
you appeared in that
Yes, my
matter.
lord.
In one of my case also, my lord, same decision has been taken.
Ah,
They allowed to supply goods and supplied and they have withdrawn the claims.
ah.
So
So
in
the-
fact, in this matter, my lord, we have supplied maximum. My lord,
I'm
quantity.
not going to look into it, but whatever may be, they let them take a decision. Issue notice making it returnable on how much time will you like to take a decision?
3 weeks time.
Take not affidavit, take a decision
Yes,
also.
my lord.
Yeah. On 22nd of May 2026. Mr. D.P. Bora appears on behalf of
All the.
all the respondents. Extra copies of the petitions be served upon him during the course of the day. The petitioner herein, who is a manufacturer and exporter of injection and other pharmaceutical products, is aggrieved by the Department Order number 582884/200068 dated 14/11/2025, as well as the rejection of its representation dated 17/2/2026. The learned senior counsel appearing on behalf of the petitioner submits that the issue involved in the instant proceedings is squarely covered by the judgment passed by this court in the case of Nestor Pharmaceuticals Limited. Versus State of Assam. Reported in 2025 SCC Online, SC, GAU 5168, wherein this court had categorically held that without there being a product department upon cancellation of the rate contract for the item, the question of going into the firm department is not envisaged on a conjoint reading of clause 5 capital H brackets 1 Roman 1 and clause 5 capital H Roman 2 of the bidding document. The learned senior counsel referred to paragraph 39 to 47 of the said judgment. Was taking into account that the issue involved in the instant proceeding is similar to the judgment, similar to the issue which was involved in Nestor Pharmaceuticals Limited, Supra. This court finds it pertinent to reproduce paragraph 39 to 47 of the said judgment. First, the respondents herein are directed. The Mr. D.P. Bora, the learned counsel appearing on behalf of the respondents, submits that the impugn order was passed on 14/11/2025, much prior to the order passed by this court in Nestor Pharmaceuticals Limited Supra, that is on that much prior to the judgment and order dated 11/12/2025 passed in Nestor Pharmaceuticals Limited Supra. First, taking into account the above, this court directs the respondents to bring on record their stand by filing the affidavits on or before 18th of May 2026. First, it is further observed that pendency of the instant writ petition shall not bar the respondent authorities to again to recall the order, impugn department order bearing the number so and so, dated so and so, 14/11/2025. By taking into consideration the judgment of this court in the case of Nestor Pharmaceuticals Limited Supra, and more particularly to the paragraphs quoted herein above.
Right.
It is more like a final order. Yes, Mr. Das.
Well, that's section 36 Pharmacy Council.
Huh?
Pharmacy.
What pharmacy?
That matter.
Pharmacy I don't take, na?
Regarding the cancellation of illegal pharmacies.
Now also.
They say, my lord, they came to know about the cancellation in February 26. Though these are orders of 2023.
I think let it go before any other bench.
They're the same exercise.
Let this matter be listed before any other bench.
In these items, my lord, I was on the last occasion, my lord, I was asked to take instruction, my lord, from the forest department. It's about, my lord, refunding the forest royalty. It's a contempt petition, my lord. Forest was not a party in the petition. So if my lord produces the last order for but
Last order 33.
18-2, my lord.
Huh?
18. Oh, sorry, 5-3, my lord.
This one.
5-3.
Item number 7.
So, my lord, I though forwarded everything, but I need some time, my lord, to pursue it.
Item number 7.
385.
Referring to Mr. P.N. Gupsami, representing the submit that once he gets the communication that is referred by Mr. B. Gugoi representing me, he may verify the present status of it. Means it must have what has happened, the PWD deposited into
Exactly.
you.
So,
And
my-
the refund has to be routed from
So
you.
contempt was between petitioner and the PWD, my lord. Forest has some role to play because money has been deposited to forest. But though, my lord, I communicated all the papers submitted by my learned friend, my lord. Because of the elections and review, I could not pursue with them. I seek some time, my lord. The old matter, my lord. I will personally take up with the authorities. But in fact, I have taken up, my lord, some accommodation, my lord, for me.
Okay, pay interest, na? Interest, 12%?
My lord.
12%. How much penalty what is the interest you impose?
Interest, I don't think.
No, whenever you have certain amount to be paid, and if they don't pay, there's no interest,
It's state, usually there is no interest,
the
but
same interest.
Yes.
Huh? I think that is 18. Let us make it 12 for you.
but originally while it was between the.
And this
petitioner the
12%
PWD.
will go from this airing officer's salary, not to the government. We have to protect the government. Government is there. So let us see who are the persons concerned, give us the names, and you deduct it from them, the interest, why should not?
4 weeks time, I will try to.
No, if within 4 weeks' time, if you pay, no interest. By the time when the matter next time comes up, if you pay,
In
no
fact, my
problem.
lord, as
But
I-
if it is not, kindly provide who are the persons concerned.
in fact, my lord, if I may submit, my lord, this amount, my lord, are deposited in the treasury. It's not that PWD on its own can send it back, my lord. Whatever amount PWD, sorry, forest has
No,
received.
I don't understand one thing, Mr. You can very well get it and you can get it from the forest.
Exactly.
It is an internal dispute between you and him. Why should the petitioner suffer?
All money goes back to the treasury.
Yeah. Give one of your contracts out there, good contracts to him, and then say that, okay, don't pursue the contempt. He's a seasonal, not a seasonal, habitual litigator.
What 22?
So therefore, he's a habitual litigator.
We have all heard about Rana construction. There are reported, we have all heard about Rana construction. There are reported judgments also.
That day, there is one matter where it was not there. This matter, I fixed it on 28.
In that matter, we had a private respondent.
Because of
20.
you
Yes,
got fed
with
up with the
sufficient
you got fed up with the PWD. You directly approached the
Mort, yes, ma'am. For the first time, my lord, here added as respondent, my lord. I think, for the first time.
Famous name, my lord, Rana construction, we all know.
Nobody likes him.
Huh?
Government don't like him. I don't know why.
There used to be another contractor who used to file a lot of cases when I joined. It was some Decca construction or something. You remember? There is to means cases after cases after cases. Anyway, we do one thing. We are not concerned how you settle between yourself, but if you, this is a compliance, non-compliance to the order passed by this court. So, okay, therefore. Mr. P.N. Goswami, the learned additional advocate general, who is also the standing counsel of the forest department, submits that on account of the elections, which recently took place on 9th of April 2026, and the model code of conduct which was issued on 15/3/2026. The adequate steps could not be taken from the forest department so that the forest royalty which has been deposited to the forest department could be verified and then reimbursed to the PWD, so that the said amount is payable, disbursed to the petitioner. This court have also taken note of the records, the various orders passed in the records. And it appears from the various orders that a stand has been taken by the PWD, by the officials of the PWD who are the contemners in the present proceedings, that upon collection of the forest royalty, they have deposited to the forest department. And it is under such circumstances, the PWD department is not in a position to refund the forest royalty which was payable to the petitioner pursuant to the orders being passed by this court. This court has given an anxious consideration to the respective submissions so made by the learned counsels, by the learned additional advocate generals appearing on behalf of the Forest Department as well as for the PWD Department. And it is a settled principle of law. The government has to speak in one voice, and there cannot be any difference of opinion between the various departments. The fact that the PWD department have deducted the forest royalty from the petitioners is not in dispute, and therefore there were directions passed in the orders which have been sought, for which compliance have been sought for by way of the present proceedings. There is also a time limit prescribed in the orders, and it is notable to mention that the present batch of contempt proceedings is already 8 years old. Under such circumstances, it is the opinion of this court that not refunding the forest royalty by the contemners, by the various departments, on the plea that one department has not reimbursed the amount and the other department have not verified, appears to be a lame excuse not to comply with the order passed by this court, orders passed by this court. Accordingly, this court fixes this matter on 3rd of June 2026. It is observed that it is observed that if the amounts to which the petitioners are and the petitioner is entitled to, on account of the orders for which compliance have been sought for in the instant proceedings, is not paid, is not refunded to the petitioner, this court would have no other opportunity, would be initiating contempt proceedings against the erring officials of both the PWD and the Forest Department. Are all the recent PWD people have been brought in?
No.
Okay.
My lord, present are not there.
Huh?
Present incumbents, my lord, are not there.
And forest, there is no party, madam.
Forest, you have not made a party also.
No, no. Last occasion, court,
Also.
I wanted me to take.
And this court also taking into account, this court further takes note of that as the requirement for seeking compliance is between the court and the contemners. Both the additional advocate generals who are appearing for the Forest Department as well as for the PWD Department, that is Mr. P. N. Goswami as well as Mr. B. Gogoi, shall provide the names of the present incumbents who are holding the post of the Chief Engineer, PWD, as well as the
Forest, man, I think.
Forest who?
PCCM, man.
PCC.
Senior officer.
The principals here, so and so, on the next day. This order may help you out
Definitely, that is what I
to
was.
act fast.
In fact, this will help.
And 16.
Deeply applied.
Yes, Mr. Sharma.
Against the seeking in a irrigation department.
Huh?
Seeking was directed by the honorable court to verify the claim of the petitioner. So there was a contractor of the department. He
Then,
has done some contractual work without any written order. Verbally, again, verbally he was asked to do the work. Accordingly, he
he
did.
got the money.
Money
Who is appearing for the contempt?
Money is more than 9 lakh something, sweater. 9,39,600.
Mr. Sharma, let me tell you one thing. When you want the contempt, you have to catch hold of the bigger person, not the chief engineer.
No, in person.
Why you are not making these people a party, the commissioner and secretary irrigation
I
department?
am the KM Gopal Sana.
He's the chief engineer.
He is the chief engineer.
Why? The direction is given to everybody, not the chief engineer alone, I suppose.
No, chief engineer in by name.
Where? Directing the more particularly they have to verify the claims of the petitioner. Has the
Yeah.
verification been done?
Page 2, my lord. Versus Gopal Sana Rajkumar, chief engineer, irrigation department. Page 2. Against
Then irrigation, where is the irrigation council?
he was directed by the, as per order, he was directed by the honorable court to verify the claim of the petitioner, my lord.
Then
As per order. Order is, my lord, the page 34.
the verification has not been done. Okay. Ms. Yuda, can you ask somebody to call Mr. N. Upadhyay? Come back.
The principal secretary, who is the respondent number 1 in this case, Your Lordship, is no longer holding the post. We are not appearing for. Our card number is not filed on his behalf, Your Lordship.
Huh? Who is holding the post?
Lordship, one Mr. Mukesh Shahu, Lordship, yes, Mr. Akashdeep has left the post in November of 2025.
Are you appearing for Padmavanta Chaudhary? It has been submitted by Mr.
NR Sharma, Lordship.
appearing on behalf of the BTC that the present incumbent holding the post of the principal secretary to the BTC
Lordship.
is one Mr. Mukesh Sahu.
Lordship.
Full stop. The counsel appearing on behalf of the petitioner, however, is not present. Taking into account the above, list this matter after 6 weeks. In the meantime, the counsel, the petitioner would be at liberty to do the needful.
May I please, Your Lord? My lord, it's non-payment of contract payment. Here's direct.
Similar situation, Your Lordship, in this case of similar situation, Your Lordship, because
Here in this case, affidavit has been filed.
But this order, don't you think it goes against your very BTC? Have you seen this order?
Lordship, I'm not in possession of the brief, Your Lordship, because I for the first time.
Out of 30.
This order cannot be complied with due
order-
respect. You see, the BTC follows the Kamserali. That is already recorded, they have taken a proposal. How can there be a direction passed like this by the coordinate bench? With due respect,
It is out of 5 lakhs.
this type of direction cannot be passed. You verify and pay within 6 weeks. Is it ever heard of?
5 lakhs paid one out of that.
5 lakhs or 1 lakh, 50,000 also cannot be passed. When, you see, the moment they have adopted Kamserali, the question is, if there is a direction passed by this court to bypass Kamserali for this petitioner, this court is violating also Article 40. It is not that the court cannot violate, the court is also violating. And with due respect,
That's
violate. Unhealthy.
now, my lord,
Getting an order like this becomes very difficult. Who appears? You are appearing? No. RB Bora is not there.
Lordship.
So we do one thing, we ask this particular contender to appear in person. As no counsel appears for the,
Or Lordship, alternatively, Lordship will give me 3 weeks, Lordship, I will have the up-to-date instruction in that.
that is what we were
We want to
also
assist the court.
inclined to hear. Mr. N.R. Sharma, who is also the standing counsel of the BTC, submits that he has been instructed to appear on behalf of the present incumbent, Mr. M. Sahu,
Lordship.
as well as Mr. Akashdeep, the then incumbent Principal Secretary BTC. He therefore submits that he would take appropriate, he would like to file an affidavit in opposition on behalf of the present incumbent. The counsel appearing on behalf of the petitioner submits that he would also file an application to bring on record to implead the present incumbent. List the matter after 4 weeks. The name of Mr. N.R. Sharma be shown as the counsel representing the respondent number 1. Yes, Mr. Anupadya, what has happened here? There was a direction to the chief engineer to verify and then to pay as per counsel only. Now the question out here is whether the verification has been done. Just find it out. We shall get it after on the 1st of, let's have it on 11th.
May, 11th of May.
11th of May. In the meantime, you just find out whether the verification has been done. I put that 11th of May for the reason that if not, verify it in the meantime.
Lost.
We have already received notice, chief engineer. Chief engineer has received notice on.
That I also know. Whether he has received notice, we are looking now. First, once you do the verification, then we can close it.
And
We'll
Lordship,
follow
the
it.
respondent is no longer holding the post, Lordship. I have seen.
No, that I also know.
Lost.
He is also not holding. So
Yeah.
therefore, I'm asking you whether he has done.
Yes, sir.
The present petition has been filed alleging willful and deliberate violation to the order passed by this court dated 10/2/2023 in WPC number 241/2021, whereby there was a direction upon the respondents to verify as to whether the petitioner was entitled to the amount of rupees 9,36,9,600 within a period of 1 month, within a period of
3 months.
within a period of 3 months, and then to make payment as per Tamsir First, this court duly takes note of that service was steps were taken against the sole respondent, and the service have been deemed upon the sole respondent on the basis of the order dated 1/4/2024 by the Lozima Court. However, the sole respondent is not present. Considering the above, this court have requested Mr. N. Upaidya, the learned standing counsel of the Irrigation Department, to take instructions, to obtain instructions from the present chief engineer of the Irrigation Department as to whether the verification which was directed by this court by the order dated 10/2/2023 in WPC number 241/2021 have been carried out? And if so, what is the present status? Full stop. A copy of the contempt application be served upon Mr. N. Upaidya, the learned standing counsel of the Irrigation Department, by tomorrow. Full stop. The name of Mr. N. Upaidya be shown as in the cause list by the registry list again on 11th of May, 11th of May 2026 for an update.
All right.
What is it, Mr. Gogoi?
So contempt case in the morning, they made a mention they received the amount, your lordship.
Ah.
It was compliance authority 3/3/2025, passing WPC number 3857/2024.
Have you paid the amount?
Yes, he has submitted in the morning that he has received the amount. A mention was made in the morning that he has received the amount. Adjournment was
This one?
yes, yes.
He mentioned it.
He could not give the details of the order, your lordship.
Okay. Sure. You have any instruction?
No, lordship. He just, even in the morning, he informed me that he has received the amount.
It has been submitted at the bar by the learned counsel appearing on behalf of the petitioner as well as the respondent that order dated 3/3/2025 in WPC number 3857/2024 have been duly complied with. Taking into account the above, the present contempt application stands dropped.
Public.
Oh, where is he? This I'm going to dismiss for default.
Lordship, this is for correction. There is an inadvertent mistake on my part, Lordship. The father name of the petitioner has been wrongly mentioned in the this
Where?
post title, Lordship. So I have made a prayer for the correction with regard to that, Lordship.
Father's name,
Father's name has been wrongly mentioned.
like Makbul Ali Majumdar.
Exactly, Lordship.
What should be the name?
Lordship, I have made a mention in the IA.
What should be the father's name? Babar.
Yes.
Huh? There's some
To define names, Lordship. Yeah.
Makbul, he has gone to the Mughal area.
Yeah.
Huh?
Yes, Lordship. And the
But-
mother is saying to define father's Lordship.
But
So
tell
there
me-
was my confusion.
Tell me, Mr. Chaudhary, that's not my mistake.
Exactly, Lordship.
Then how do I do it?
Lordship, I'll file an application. This application has been filed for amendment of this one, post title. So since it has been disposed of, so I'll keep it on record, and on the basis of that, Lordship can pass an order.
You have filed that application.
Yes, for amendment of the post law.
Where?
This particular IA is for the amendment.
With an IA?
Yes, Lord.
This IA is for amendment.
Yes, Lordship. Since it has
Of?
been disposed of, Lordship, the amendment of the cost title of the writ petition, Lordship, which has been disposed of.
So this is for amendment of the post title of the,
Yes, Lord.
and where's your age? See the affidavit filed at page 9. No age. Defective affidavit. I'll help it. Tomorrow he may say, my father's name is somewhere else. What did he put? Let us see. If you want this mistake, then we should recall the entire order. See, Babul Uddin Majumdar,
Yes.
aged 53 years, son of Makbul Ali Majumdar.
Exactly.
And now he wants to say that Babul Uddin Majumdar, aged blank, son of late Babar Ali Majumdar
Exactly.
and late Aisa Begum Majumdar, resident of Uttar Kashmir.
Other thing as well.
Then
Other
phone
thing,
number is also different.
other thing is correct, Lord.
Phone number is also different. What is the matter about?
Matter is with regard to Lordship, this land acquisition. This
Then?
the land acquisition, thereafter the application has been filed with regard to some objection. The person, the
Show me something that is the Babul Ali
then Lordship, I will
Majumdar.
do one thing, Lordship. I'm not pressing this application. I'll file additional this affidavit
Yeah.
along with the copy of the Aadhaar and the PAN card.
Aadhaar,
Aadhaar and PAN card to
PAN
justify
card,
the Aadhaar to justify the
birth certificate. Bring all those.
no, Aadhaar card. I will attach, Lordship.
No.
Aadhaar card.
It's very difficult. And tell me how this affidavit can at all be taken. We should take care of this respondent, the registry. See this affidavit, no age.
No age. Yes, that is the fault is there, Lordship.
And the earlier affidavit,
Yes.
the best part is another thing. The age is struck off. You want to hide your age also.
No, Lordship.
Why?
There is no reason for this hiding the age.
No, yes. Kindly see. You
Age is-
don't know whether it is 51 or 53. Something wrong with your age. Filing an affidavit
It's not
later
like
on
that,
will
Lordship.
become something.
Lordship, I keep it pending, Lordship. I'll file additional affidavit enclosing a copy of the Aadhaar card, Lordship, to clarify the entire step.
The counsel appearing on behalf of the petitioner admits that you file an additional affidavit, list the matter of 2 weeks. 3 weeks?
Okay.
3 weeks. I conflict. You have not filed affidavit.
No, I for respondent 8, we just entered in yesterday. We just filed a work yesterday.
Veterinary.
Department Lordship. So far, in my information, Lordship, the proposal for subsidiary, proposal for subsidiary,
Subsidy.
proposal for the subsidy of the original project, Lordship, that was submitted by the petitioner, Lordship, although some documents were missing at that proposal. Therefore, the department asked him that to submit the relevant documents. And Lordship, after that, Lordship, on 27, Lordship, the one decision will come out. Regarding the subsidy of the whether subsidy will allowed to the petitioner or not. On 27, the department will take a decision, Lordship.
Where is the scheme?
My lord, scheme is not here, my lord. Project is there, my lord. Annexure 2, my lord.
Scheme is not there.
Not there, my lord.
Then
Details scheme,
on what basis are you filing the case?
my lord, on the basis of project,
Huh?
project report only, my lord. Project report has been prepared by the department, my lord. That's why they are relying upon that, my lord.
You are asking for subsidy.
Yes, your lordship.
Subsidy is, what is a subsidy? A subsidy is the amount which is being paid by the government
Yes, your
on the
lordship.
basis of some policy.
Yes, your lordship.
Your entire basis of your case is that on the basis of that policy,
Police.
you have changed your position and thereby want to bring the concept of promissory estoppel.
Yes, my lord.
Now, how do you bring the concept of promissory estoppel without the policy? Tell me,
Yes, my
give
lord.
me a good idea how. Possible?
Yes, Lordship.
Possible? Not
No,
possible.
not possible, Lordship.
So your petition is bad. We dismiss it.
My lord, kindly allow me to file an
Dismiss.
additional affidavit, my lord.
You should. This is a good case for dismissal, writing is.
Yes, my lord.
The petitioner herein has approached this court claiming claiming the being aggrieved by the non-release of the subsidy amount of rupees 29,03,500 in respect to the piggery set up by the petitioner under the Rural Self-Employment Training Institutes. The said claim for the subsidy is based upon some policy of the government. However, the said policy or the document, have not been enclosed. Mr. M. Saike, the learned counsel appearing on behalf of the petitioner, submits that you would like to file an additional affidavit, bringing on record the said policy, on the basis of which the petitioner claims entitled to the subsidy amount. List this matter how long? 2 weeks, 2 years, 1 month?
My lord, next week.
What?
Next week, my lord, by 1 week, I can file my lord.
List this matter again on 18th of May 2026. In the meantime, the additional affidavit be filed.
Public.
Lordship, this matter,
Item number 23, my lord. 23, 46, 47, 48, 49, 50, and 51. Now, there was a tender which was issued by the IOCL. Then there was a corrigendum which included a fact that the tenderers were allowed to bid on vehicles which were currently flying under different tenders, my lord. That clause is at page 138. Page 138. 138, my lord. The second last paragraph, the rightmost column. So what has happened, my lord, on the last order?
Have you filed your affidavit?
No, my lord. In fact, we were directed to take a stand on the reply that the petitioners have filed.
we have filed our submitted our representation, Lordship.
Representation,
the
my
last-
lord. That
earlier
representation in all the petitions, my lord, we were directed to take a stand, my lord, on whether to allow or to dispose of, my lord. My instructions are that we are in the process of disposing of those representations. If your lordship kindly grants us maybe 2 weeks' time or a week's time, my lord, we'll have a definitive answer as to what we have taken on those replies.
In all the matters,
In
same.
23, 46, 47, 48, 49, 50, and 51. Similar orders, my lord.
All the cases.
All the cases. Okay.
To take the order dealing, but you will support the bill. What is the issue involved?
The issue, my lord, is that the petitioner were directed that initially an LOA is issued. Now there was a term, with stipulation in the tender, that if you are submitting a vehicle which is currently registered under a separate tender, separate tender under the IOCL, you can bring those vehicles under the tender, provided that you have to change the PESO license and the RC in the name of the current tenderer within 4 months from the date of issuance of the LOA. Now the LOA invariably had been issued in the month of September 2025 to all the tenderers. Now within those 4 months, there are certain trucks which they sought to bring under the present tender. The PESO license and the RC were not transferred in the name of the tenderer. So what the IOCL did was that the IOCL cancelled those particular trucks, not all the trucks, particular trucks. Now they were aggrieved. So they had filed a representation praying that they be kindly allowed to operate those trucks which they have defaulted. Transference of the PESO license and the RC within 4 months.
How is it possible?
No, so they have sought an accommodation from our part.
Yes.
The clause, my lord, the relevant
They
clause,
sought for extension of the period
extension of the day.
from 4 months beyond that.
Beyond that, because the 4 months would ideally, my
As
lord,
of now, have they complied with it?
they have submitted certain documents regarding certain trucks, and certain trucks have not yet been, the application have not yet been submitted. In all the cases, my lord, the trucks of the tenderers, the relevant documentation have been transferred to the name of the tenderers after 4 months of the issuance of the LO.
It's okay, but in some trucks, it is not done till now.
No, and some trucks have been done, and the trucks which have been complied with, my lord, we have allowed them on road, my lord.
You see, after 4 months also you have allowed.
No, before 4 months.
Before 4 months too, you are going.
I'm going to allow, my lord. And
There's no problem. But
after 4
after
months,
4 months, you
yeah.
have not.
yes, that is when
And that is the representation they have submitted.
they have submitted.
Lordship.
And you are to take a decision.
I'm to take a stand on that. Take a decision on that, my lord. And we'll be taking it within the next week, my lord.
You take a decision, don't take a decision, that's your lookout. We are not concerned.
My lord.
That is between you and him.
My lord.
But when he has approached this court as to whether it is the condition is live, but has he challenged that condition?
He
Lordship,
has-
we have certain conditions, actually, page number 154. You can see
No, no,
our
you challenge that condition.
lordship.
they
Because
have-
this court does not work on mercy. Mercy is actually outside the door. So have you challenged that condition?
Lordship, we didn't challenge the condition, actually. We saw some of the reasons why we couldn't fulfill.
No, no, that is
Lordship.
immaterial.
Lordship.
The condition is specific. That
Lordship.
look here, if you have a license out here, you have used this particular truck in some other tender,
Lordship.
in name of some other tenderer. Later on, this tenderer concerned, you want to use these machines out there in this tender. Then in that regard, you have to change the name in the RC and as well as in the PESO license.
Lordship.
These are to be done within 4 months from the date of the LOA.
LOA.
That is the condition.
Condition, Lordship.
Now, you could not. It's an admitted fact. Maybe for good reasons you could not,
Lordship.
or maybe for justifiable reasons you could not. But the fact remains that is a condition.
Lordship.
Now, can this court interpret or decide anything in respect to the said condition without a challenge to that condition?
Yes, Lordship,
That
basically,
question is very simple.
we challenge actually the show cause notice that has been served
So what
upon us,
notice is
Lordship.
not going to do. The fact remains that you have not complied with.
Lordship.
So unless you challenge that condition, how is it possible? Who appeals for the other matters?
My lord, the IOCL, my lord.
I use
But same set of.
same
counsel.
Lordship.
Same person.
Yeah, we represent the 6 petitioners.
Okay, six.
Seven
My, my question is, without a challenge to that condition, can you proceed? Where's the condition? Let us see.
My lord, page 138, my lord. Page 138 of the first retribution, my lord, page, item number 20. This condition was introduced as a way of a corrigendum. my lord.
Original.
Where?
Starts at page 136, then my lord, 138, the second last paragraph in bold.
In
my lord.
case the bidder fails to submit the required documents with the change of name, etc., within 4 months of the issue of the LOI, suitable penal action shall be taken, which may include EMD forfeiture, caution money forfeiture, termination of the order of the TTT, and blacklisting of the TTT. Under no circumstances will the aforementioned timeline be extended. In such cases, the contracting corporation reserves the right and shall be at liberty to induct TTT as per the methodology mentioned in the tender to fulfill the shortfall. So therefore, without a challenge to this condition, how can this court interpret? Michael,
Lordship,
that case, we dismiss?
no, Lordship, kindly, give us 1 week time, Lordship.
Or
Lordship, my senior will
who's your
better,
senior?
Mr. S. Borthakur, Lordship.
He's not there.
He's not today, Lordship, because of bar council election, Lordship.
He, the other bar council candidates have appeared. Why not him?
Lordship, then give.
You are not supposed to campaign today.
No, Lordship.
Please, can somebody campaign today?
Give us.
I'm asking you.
He will come, Lordship.
At the time of election, can somebody campaign?
No, Lordship.
Then what is he doing there? He should be appearing so that we could have finished up this 5 matters today. Dismiss.
Lordship,
6.
the matter may come at 2, Lordship.
Why? So that he knows the fate that his campaigning did not do well. What is it?
No.
Some reason must be there. But my question is very specific. You have to answer this on the next day
Lordship.
with your senior. Without a challenge to this condition, can this court entertain this instance?
Lordship.
Okay.
Lordship.
We go on the question of entertaining the writ petition,
My lord.
keeping the maintainability of the writ petition on the next day.
My lord, I will grateful.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. M. Sharma appears on behalf of the IOCL. Mr. M. Sharma, the learned standing counsel of the IOCL, submits that prior to filing of any affidavit, a preliminary question be adjudicated by this court as to whether the writ petition is at all maintainable without a challenge to
Corrigendum, my lord, dated
The-
4/4/2025.
without a challenge to
Conditions.
the part of the corrigendum which had led to the impugned action. The learned counsel, standing counsel, specifically refers to the following portion of clause 5. Of the following portion, that is inverted comma লিখিব হ্যাঁ page 138 ত দিব 80 mark কৰি দিছো এটো which is quoted here in below, which is a part of the details of the PQC documents and requiring that the bidder has to change the name, has to submit the required documents with change of name, etc. within 4 months of the letter of the LOI. And admittedly, in some of the trucks which the petitioner in the instant proceedings have bidded for, the petitioner were not able to submit the required documents with change of name, etc., within 4 months of the issuance of the LOI. So taking into account the said submission, this court inquired with the learned counsel appearing on behalf of the petitioner, who submitted that his senior is not present. His senior, Mr. S. Bottagur, is not present in the court today, and therefore sought for an accommodation. Accordingly, list this matter again on 6th of May 2026. On which date the maintainability of the incident with petition would be taken up on the aforementioned issue. Preliminary issue so raised. This order will follow in the others. Huh?
Similar.
Oh, you have also some preliminary objections?
Lordship, there is an interim order. Interim order.
Interim order for what?
Lordship.
You are not satisfied. I am not satisfied with your case. Yes. Ah, what is this?
Lordship, I have a prayer.
What prayer is this?
The arguing counsel is not available today, Your Lordship. So this matter may kindly be fixed on 29th of this month.
20?
29th of.
Why?
The arguing counsel is not available.
You have filed objections?
No, Lordship. No.
Sir, as a case pending before a cornerstone.
I know that.
Yes.
I know that now he wants to change from Jurhat to something, isn't it the case? Ah,
In Dolesar.
Hmm. and then
Listeners where the history referred to the Superintendent of Police Border, Golfar.
why?
FP case is pending in Kamrup Metro Lordship.
Then
There is direction of the Honorable Court while
Hmm.
disposing of the petition that he should approve the distributor border Kamrup Metro who informed all the details of the case. Participant said proceeding.
that case.
Your Lordship, let my senior assess Your Lordship.
Chalo. Let your senior come. When your senior wants to come,
On 29th.
any particular time? Huh? Number? Absolutely no.
29th.
The counsel appearing on behalf of the applicant seeks for an accommodation. List this matter again on 29th of May 2026.
Deeply obliged, Your Lordship.
এই আগৰ কেছ কেইটা আগৰ অৰ্ডাৰ য'ত আছিল নেকি সেইবোৰ অৰ্ডাৰ য'ত আছিল আৰু সেইটো 45 এইবোৰ চব লিষ্ট ফৰ এডমিশ্যন কৰিব দেই all this matter be listed for admission. Yes, what is this?
My lord, may I, Lord? They filed, the respondent has filed their written reply, my lord. Affidavit in opposition.
Hmm.
But only one problem is there, my lord, that 12, there's 3 planning. This is a T subsidy matter. Now, there's 3 plan. The 11th plan is expired in 31st March 2012. Then 12 plan came into force.
They have filed the affidavit, you have not replied?
No, therefore, that 12 plan, the full text of 12 plan not in the records. They have filed, but not full.
Why do you want you?
So we
why-
have to file that by an affidavit, my lord, the entire. 12
So you want to file a reply?
My lord.
Mr. B. Dotto, the learned senior counsel, appearing on behalf of the petitioner, submits that the affidavit in opposition has been filed with respondent number 2 to 6 on 25/3/2026, and the petitioner would like to file a reply. List this matter again on
Yes, it is possible, my lord, because
2nd of May 2000,
second,
22nd of May 2026.
25 is possible.
On 25th of May 2026. In the meantime, the reply be filed on or before 21st of May 2026.
Grateful, my lord.
Yes, Mr. Vachaji, on this side of the what do you call the podium?
My
Let's see
electricity connection has been,
Huh?
my
Oh,
electricity.
that matter.
Yes.
Lordship, he has also strike before the lower court also, and I have filed a counter claim against his title suit.
I remember that matter. You now file the suit for specific performance. Go there, fight it out.
But the electricity connection.
What electricity connection? Go there.
Yes.
Why should we entertain?
Section
There
56.
is a dispute. There is a big dispute. Why should you? And on one occasion when they visited, there was nobody. It was a jungle.
And Lordship, illegal enforcer
that
has
was
no
his
right
stand.
at all.
The Lordship may kindly look at the first instance, he says that it was a dilapidated condition. Second instance, when he filed affidavit, I mean the PTCL when they file affidavit, they say there is a default in payment. And they annexes a document. Lordship may kindly see their affidavit. Paragraph 4. No, the paragraph 5. Page 50 of their affidavit. May I read mine?
Read.
Even it states that the petitioner's premises earlier had an electricity connection standing in the name of Surajit Roy, bearing consumer number so and so, which was disconnected on paragraph 5 of the affidavit filed by APDCL. Page 50.
No, you have not made the pages. The opponent said that the petitioner's premises earlier had an electricity connection
Standing in the name of Surajit Roy, which was
non-payment.
disconnected on so and so due to non-payment of outstanding dues.
Ah.
It is further submitted that an amount of rupees so and so remains outstanding as on date. And they annexes a last electricity bill. So
who is Surajit Roy?
Surajit Roy was my earlier owner who expired.
And
now he is the wife.
I'm respondent number
Wife
4.
of
I am the
Surajit
wife
Dutta.
of that.
Now, who is in possession?
I am in possession.
Illegal possession.
Possession
But
is
about
there.
Yes,
Possession is my
illegal possession.
Possession is there.
Possession is there, but illegal.
So you take temporary connection.
my
8,000 which means the moment I give him the right. How do I give it?
For temporary connection, very.
No, you see, the moment I give him say that he has to pay his right in respect to the suit would be affected.
Yes.
And he wants that only.
Yes. Then it will be a temporary connection.
And Lordship, if he got the
Temporary
connection, if he got the connection, he can recharge his mobile phone. And after recharging, he will write anything in Facebook.
no. That's a different thing, my lord.
What?
You see,
What is this recharging business?
recharging his mobile phone.
Ah.
As there is no connection, now if connection, he got the connection, he can recharge his mobile phone. Thereafter, he can write anything against me also.
No, I can
He can recharge
that
this
somewhere
outside in the
else.
court also.
Yes.
How does it matter? My question is, if he wants a temporary connection, you are going to give it. But whatever may be, you give him a temporary connection if he wants, because he is in possession, admittedly. You have filed a suit, Mr. Counsel.
Yes, I have filed.
He's also filed a suit.
Yes, Lordship, already it is done. Lordship,
Who has filed a suit?
I filed the suit, he filed counterclaim.
So therefore, and what is his counterclaim? Let us see his counterclaim. Where is it?
No, it is not with me, man.
Bring it on record. Then it will become easier. The moment he says that you are in possession for recovery of possession, automatically the thing becomes better.
this is the counter claim.
He is helping you to get the order today itself.
Lordship, problem is that connection is in my name. If he got the connection, I have to pay the bill.
Not in your name, in your husband's name. So you are in possession. He is asking for recovery of vacant possession. So therefore, if he applies as per that, you give the temporary connection, not permanent. Heard Mr. Bhattacharjee, the learned counsel, appearing on behalf of the petitioner. Mr. KP Pathak appears on behalf of the respondent numbers 1, 2, and 3. And Mr. So appears for the respondent number 4. The petitioner herein, who admittedly is in possession of a building, of an RCC building, pursuant to an agreement dated
9/12/2014.
9/12/2014, is aggrieved by the actions on the part of the respondent authorities in disconnecting the electricity power supply, and as such has approached this court. The APDCL authorities have filed an affidavit in opposition stating inter alia that the electricity connection stands in the name of Sri Surajit Roy. They have mentioned.
Yes.
Bearing consumer number 3865, page 58, which was disconnected on 14/11/2023 due to non-payment of the outstanding dues of an amount of rupees 8,277. First, it is also seen that in the meantime, certain disputes have arisen between the petitioner and the respondent number 4, whereby the petitioner has sought for specific performance of the agreement dated 9/12/2014 against the respondent number 4, whereas the respondent number 4 has filed a counterclaim in the said suit and specific performance of the agreement dated 9/12/2014 by filing a suit being title suit number 83/2025, which is presently pending before the Court of the Civil Judge Senior Division, Punitpur at Tejpur. It is also seen that the respondent number 4, along with her daughter, who is a minor, have joined together to file a counterclaim in the said suit, seeking the termination of the agreement for sale dated 9/12/2014 and for recovery of possession. From the dispute between the petitioner as well as the respondent number 4, it is apparently clear that the petitioner is in possession of the building in question, which is the subject matter of the agreement dated 8/12/2014. It is a well-settled principle of law that supply of electricity is an essential What is the term? Essential?
Essential service.
Is an essential service, as has been held by the Supreme Court in the case of Dilip Dead versus so and so, reported in so and so. And as such, if the petitioner is in possession of the said, the respondent authorities cannot claim, cannot deny the essential service in turn, as is also essential service, subject to the satisfaction of the terms and conditions of its regulations. What is that regulation? AERC 2017. Full stop. This court also cannot turn a blind eye to the fact that the electricity connection earlier admittedly was in the name of Surajit Roy, bracket, since deceased, who expired, who is the wife, husband of the respondent number 4. First, there cannot be a continuation of an electricity connection in the name of a deceased. And the petitioner also would not be entitled to have a permanent connection, since a title over the said land and the building, which is the subject matter of the agreement for sale dated 9/12/2014. Considering the above, this court therefore disposes of the incident with petition with the following observations and directions. The petitioner would be at liberty to apply for a temporary connection in respect to the building in his possession in terms with clause
4.5.
of the regulation. And upon filing of such application, the APDCL authorities shall consider the same and provide the electricity connection subject to satisfaction of the terms and conditions of the said regulations. No, that I cannot. No, I'll make it clear. Therefore, that is for temporary connection. Na? So therefore, I mentioned. This court has specific, in number 2, this court has specifically not directed the petitioner to pay the outstanding amount of rupees 8,000 so and so, which is claimed by the petitioner which is claimed by the APDCL authorities from the as payment in the name of we do one thing, direct him to pay because he was enjoying. Yes. But on the basis of that, no equity shall flow to him. This court further directs the petitioner to this court further takes note of that as the petitioner claims that he was in possession of the building at the time when the electricity connection was there, the petitioner is directed to deposit the amount of rupees 8,000 so and so at the time of submitting the application. First, It is observed that deposit of the said amount shall not affect the rights of inter se rights of the both the petitioner as well as the respondent number 4 in title suit number 83 of the 2025. Number 3. This court further observes that the permission, that the direction so passed in clause 1 herein above, thereby permitting the petitioner to the epidicial authorities, number 3, the epidicial authorities on receipt of the said amount of rupees 8,000 so and so shall close the account of connection, permanent connection in the name of late Suraj, in name of Surajit Roy, bracket since deceased. Push next. This court further observes that the direction made in clause 1 herein above, thereby permitting the petitioner to apply for a temporary connection in terms with clause 4.5.2 of the so and so regulations 2017, shall not create any equity in favor of the petitioner to claim a right in title suit number 83 of 2025.
All future payments should be done.
What?
After temporary connection is given to him, future payments, he shall be.
Be in his name only. If he doesn't pay, he will disconnect.
All lies.
Yes.
My lord, in this matter, the respondent issued tender in January, February 24, 4 tenders. I submitted bid, my lord, but after expiry of 90 days, my lord, bid period, they have refunded them. Thereafter, my lord, in August 21st of August 24, they issued my lord, the tender for 7 works. I submitted bid for 5 works, my lord. They delayed the my lord, same, and LOA I think issued it 29th of March 25. My lord. At that time, my lord, started, my lord, April, May, flood was there. My lord. So I submitted request that it will not be possible to immediately start the work. So no request has been considered. In respect of 2 works, my lord, there was no flood. So I submitted all the documents, and in respect of those 2 tenders, my lord, they have issued the work order only, my lord, in on 24th of September 25, my lord. I easily could have done, my lord, at that time, my lord. But at that time, my lord, because their stringent terms are there, in April, my lord, I cannot start, my lord, because I have to execute the, they have to issue the work order within 21 days, my lord. So subsequently, they have annulled the contract and.
Where is the 14.7 order?
77, no, page 77. There the ground is different, man.
Huh?
The ground is different, man. Non-furnishing
Has
of
not
required
furnished the requisite performance security after issuance of the letter of
Non-delivered.
acceptance in favor of the bidder within the specified time stipulated under the ITB 50 of so and so, the bid security of so and so is therefore forfeit.
Same ground, man. Not that delay.
Because after issuance for LOA, my lord, we have to submit the bank guarantee and other things, my lord. And they will issue the work order within 21 days. They will issue the work order within 21 days. My lord. So at that time, it is not possible to start the work. That is why we submitted.
No, I'm not on that.
Yes.
Whether your bid validity was there at the time when the notice invited that the LOA was issued.
Bid validity was expired.
Then if it is expired, then they cannot impose upon you. Where is your bid valid?
In 90 days.
Where?
My lord, it is 21/8/24.
Let us see.
Yes.
This is the request for bids, huh?
Page 40, my lord.
Page 30.
40.
840. Okay. Why all these cases are filed together? Different thing. Anyway, what is the,
One tender, my lord.
where is the terms and conditions of the contract? Which is the contract for which you are asking this relief? 14.7 you are challenging in which contract?
Well, for five works, my lord, I submitted tender.
Which tender?
This is the page 40.
Page 40,
Page 40,
not the
seven.
other one.
No,
Okay.
only 40, my lord, this 7 works.
21st of August 2024. Okay, which are the contracts you have bidded?
Zero one, my lord, 02 and 02.
Huh?
We submitted ten bid, my lord, in 1, 2, 3, 4 and 7.
Where?
1, 2, 3, 4 and 7.
1, 2, 3, 4 and 5.
7.
1, 2, 3, 4 and 7. Now,
Yes.
these LOA were issued when?
The LOA was issued in 29th of March 25.
Where?
Yes. Page 52, my lord.
Page
52. That is the series. After expiry, my lord. Long,
So within 21 days, you were to submit the ITV.
my lord.
So these LOA were issued for all these 5 works.
5 work.
Now what has happened?
My lord, at that time, my lord, my lord, rain started. We just started. I have submitted request on my lord, page 57. We have shown, my lord, that these works cannot be started immediately.
No, but Mr. Sahewala,
Yes.
the completion period is 18 months, 24 months, 24 months, 18 months and 12 months.
Yes, but
Then why do you say so? No, you are going to get this flooded period during once also.
But the groundwork is to be completed, my lord. After that, we can.
No, the question is, did you refuse the letter of acceptance?
No, we submitted request on my lord.
Where is the letter of acceptance refusal?
Well, this is the request on my lord. That is why we have submitted. Page 57.
Page 57.
Yes.
Okay. Now, what is the letter of alia? Have
Yes,
you
I like to
submission
submit
since I
my
acknowledge the demand?
accepting the quoted
Sir,
debt
as
source.
per the register with the proven record of neither so and so, however, considering impending monsoon and the good current ground condition, immediate execution is not in the light of AR. I request to submit the notice to proceed with work until the next working session commencing so and so. I solicit AR. Then,
Nothing has been done, my lord. I submitted.
no, that is okay.
Yes.
But the fact that you should not accept the letter of acceptance,
No,
you are
have not
requested
given
to
any-
submit the updated methodology and
No, no,
revised
this-
program requiring so and so.
No, I
You
thought
should
that-
have said that I am not accepting it.
Yes.
You have not said that you are not accepting the letter of acceptance.
Actually, my
You
lord,
wanted the deference of this period of notice to proceed to sometime in the month of September.
No, that was, my lord, in respect of 2 works.
No, this is for all these works. This is what has been mentioned at page 60.
My lord, if it would have been September, my lord, I could have done it.
No, kindly see page 60.
Page 60.
In the light, I therefore request you an extension of the notice to proceed with the work until the next working session
Yes.
commencing September 2025.
Yes.
So in respect to these 5 works, you have said that. But why haven't you refused the letter of acceptance? That if you have given it at a later point of time, I am not. Why on earth you have not enclosed the tender conditions, whereby it says that the bid validity is for a particular period. Beyond that, it would not be taken. You must have extended the bid validity. You accepted the letter of acceptance, and now can you say that you extend it so and so and give me more time? Anyways, these are works for 24 months, 18 months,
Well,
12 months, and you are not able. Good, rightly done. With
My lord,
your case,
At page 60, my lord, it has been written, my lord.
page,
In page 60,
yes,
submission. We sincere, for submission, my lord, in view of the above situation, a feasible work program for the current period will be illogical, unrealistic, and not feasible to achieve the milestone goal as per the contract, the condition of the contract. We said, my lord.
No, no, why didn't you refuse the letter of acceptance? That it is beyond the bid period. You have not enclosed that document. Go and file a civil suit. We are not going to look into all this. We dismiss it. What do you say, Mr. Gogoi?
Yeah,
We should
in
dismiss
fact, my
it.
lord, the argument has been made regarding my lord delay in my lord
No,
application of
no,
the
no,
court.
no. We dismiss it with
They have
cost.
filed any
How much
affidavit also.
cost?
Since a long time, they have not filed affidavit, my lord.
Not necessary. This is, if I was holding in the matter in the motion state, I would not have issued notice to him. Notice is not necessary here. The fact remains that you have not mentioned that you are not accepting the letter of acceptance. It is beyond the bid period. If it is beyond the bid period, the question is different. That is not your case.
Sir, can it be fixed next week, my lord? I can fix it.
Next week also I am there. Dismiss
Yes,
it.
no, I'm not for that, my lord. I'm not for that, my lord.
But this is it. That case. What do you say, Mr. Gogoi?
Well,
We should dismiss it today or next week?
that I leave it to us. That I leave it to also. They cannot
Is
improve it
there
now.
case to be discussed? I think go to civil court. You still have time.
Yes.
Go before the civil court. You portray all this.
Next
No.
Tuesday, my lord, next Tuesday.
What next week? We have to spend so much of time.
On that day, my lord, your lawsuit need not take time, my lord. Lawsuit is that if I can, that's all.
We do one thing. Today is Wednesday, na? We have it on Friday. On Friday, you produce the letter that particular you only look into as regards the bid value. Just get your instructions from your client as regards the bid validity. If you have a bid validity beyond this period, then you may have a case that if it was beyond the bid validity period, then the letter of acceptance could not have been issued. But you should have also refused the letter of acceptance. Or we may take it as an implied refusal. But the fact remains that if you have a case that it is beyond the bid validity period, then it's a different. Because normally the bid validity is for a particular period.
90 days. 90 days.
No, you may have granted extension, otherwise they would not do it.
So, my lord, here the petitioner submitted the performance security, my lord, pursuant to the letter of acceptance. Then why is the question of bid validity, my lord? The ground
Two works, my lord. Those works are going on. This is all three works. Two works are going on, my lord. There is no difficulty because there was no flood, my lord, no water. So
Now, how
three
many
works-
cases you are now asking for this?
Three.
Three.
The case 3, 4, and 7.
3,
4 and 7.
7.
1 and 2 I got.
But your justification does not seem to be good. Let me tell you why. They give you in the month of March. March, there is no rainy season. Rainy season comes in the month of July.
No, April, my lord, I have given, my lord, on that.
Mr. Sahiwala, I stay in Assam. I'm not a judge from outside. The rainy season does not come till the month of June last week or in Assam. Rainy, when we say, is the monsoons. Not these intermittent rains like that day which happened. It was an intermittent. We normally don't have these type of rains, torrential rains. Now, let us take kindly come to page 40, number 7.
Yes.
This is 12 months.
Yes.
Now, when it is 12 months, if it is in the month of March, you could have very well done it. And then you would have done it, or if you let us take it in the month of September, it is being given. Then September again, you have a month of rainy season in between.
The thing in this construction of bridges, the groundwork is very important, my lord. In rainy, when rain is there, water is there, my lord, the groundwork cannot be done. Upper works, my lord, that can be going on, my lord. So that is why, my lord,
Anyway, let us dismiss it on Friday. This is the matter on Friday. On which date, Mr. Dear Sahib, the senior counsel shall apprise this court that as regards the works at serial number 3, 4, and 7, in respect to the, as mentioned in the request for bids dated 21/8/2024, was the letter of acceptance issued beyond the bid validity period? The tender document in respect to the said request for bid be also produced on the next.
Hello.
Yes,
Lordship, on the last occasion, we have already placed our instruction, which indicates that an amount of rupees 1,21,956 is admitted, Lordship. That amount is admitted.
and remaining is not admitted.
Not admitted, Lordship.
My lord, in this case, the order was passed by the DC, and thereafter the vehicle was used, handed over to the police. Thereafter, the same was used by the CRPF.
Huh?
Thereafter, the vehicle was used by the CRPF.
Vehicle was?
Used by the CRPF.
No. Here they say you submitted bills for the initial period from 1/12/2022 to 31/1 a year, which was sent to the APO so and so for an amount of which is under process. Remaining as regards from 1/10, remaining bills from, however, no higher bills were submitted by the petitioner for the period from 1/2/2023 to 31/5/2023 and 1/11/2023 to 36/2024.
We have submitted, my lord, that is in page 30.
Huh?
We have already submitted before the SPO. Page
Where?
30, 31,
Page
page 30, 30,
31.
30, 31.
Where is the receipt?
It's below, my lord.
This is given to the motor transport officer.
The controlling officer is the officer.
Moreover, Lordship, they have already verified the records. Records indicates that for that period, they have not submitted the bills.
That is what I am also saying.
Lord.
Then there's no receipt. The tax invoice, where is the receipt? Finally come to page 38, 40, no receipt.
But there is in 30, we have already seen.
No receipt. You do one thing. You take this amount of year, we direct them to deposit, pay this within 6 months.
Lord.
In the meantime, you are at liberty to submit the bills and they will duly considered.
Alright.
As per law.
Lords.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. So-and-so who appears on behalf of the respondent. The petitioner has approached this court. The petitioner, who is the owner of a vehicle, being Tata 407 water tank, bearing registration number AS09 AC 3219, is aggrieved by the non-payment, non-release of the entitlement of the petitioner for hiring of the same vehicle of the petitioner. At paragraph number 4, at paragraph number 6, na? At paragraph number 6 of the petition, the petitioner states that the petitioner is entitled to an amount of rupees 8,39,319 for the various periods with effect from 1/12/2022 to 30/6/2024. And the details have been given in the form of a table. On account of the non-payment, the petitioner has approached this court by filing the present writ petition. This court, by an order dated 8/12/2025, issued notice seeking a response from the respondent authorities. In pursuance thereto, an instruction has been placed by the Senior Superintendent of Police dated 6th of March 2026, which is kept on record and marked with the letter X, by an order dated 6/3/2026 itself. In the said instruction, it is stated that the bills for the period from 1/12/2022 to 31/1/2023 of an amount of rupees 1,21,956 have been verified and have been sent to the headquarters, Assam Police Headquarters, for necessary sanction. However, no bills for the period from 1/2/2023 to 31/5/2023 and 1/11/2023 to 30/6/2024, as have been mentioned at paragraph number 5 and 6 to the writ petition, were received. It is the opinion of this court that as the amount of rupees 1,21,956 have been duly verified and has been found that the petitioner is entitled for the period from 1/12/2022 to 31/1/2023. Appropriate directions can be issued to the respondent authorities for payment within a reasonable period. Insofar as the other bills are concerned, more particularly for the period from 1/2/2023 to 31/5/2023 and 1/11/2023 to 30/6/2024, which the respondent authorities have stated that they have not received such bills, and liberty can be granted to the petitioner to submit fresh bills for due consideration for payment, and accordingly, upon due verification, the said payments can be made. Accordingly, the instant petition stands disposed of with the following observations and directions. The respondents herein, and more particularly, the respondents herein are jointly and severely directed to pay the amount of rupees 1,21,956 to the petitioner within a period of 6 months from the date a certified copy of the instant order is served upon the respondent number 3. 3 na?
6, Lord, more particularly respondent number 6.
to the respondent number 6. Number 2. The petitioner is granted the liberty to submit fresh bills fresh oblique duplicate copy of the bills. Duplicate copy or fresh bill? Because the original bills he has already submitted. Duplicate copies. The duplicate copies of the bills for the period from 1/2/2023 to 31/5/2023 and 1/11/2023 to 36/2024 to the respondent number 6. Upon such submission being made by the petitioner, the respondent number 6, along with the other concerned respondents, shall duly verify the same, and if found entitled to, the payments being made in respect to the said amounts after, and payment being made to the amount to which the petitioner is entitled to. The said verification be carried out within a period of 2 months from the date of submission made by the submission of the duplicate bills by the petitioner for the period aforementioned, and 6 months thereafter upon the payments be made to the petitioner upon being found entitled to. With the above, the petition stands.
Great people of ship.
Yes, you don't appear before other courts, you appear only before me. One appears for the petitioner on call. Yes, tell me.
Manas, like on the last occasion, my learned friend was supposed to bring instructions and file affidavit. However, Manas, some certain developments have taken place. Manas. Our principal grievance that we had pertaining to our conversion of our IMFL on license from my lord from on to off license has been agreed and has been my lord converted. My lord. Thank
So
you.
nothing remains.
Nothing remains. My lord. So your lordship can very well close it.
Mr. H. Buragoy, the learned counsel, appearing on behalf of the petitioner, submits. Petitioners, na?
Yes, my lord. There are two petitioners.
Petitioner submits that the grievance of the petitioner have already been redressed by the approval of the conversion of the IMFL on license of the petitioner to IMFL off license in rural areas with regard off license by the order of the Commissioner of Excise dated 12/2/2026. A copy of the said order is kept on record, which have been placed before this court, is kept on record and marked with the letter X. The learned counsel appearing on behalf of the petitioner therefore submits that the petitioner therefore would not like to further pursue. The above, the petition stands closed.
We have a stay order that can be vacated.
Huh?
We have a stay order that can also be vacated.
The interim orders, if any, stands vacated.
Obliged.
Oh, this is a review application, madam. Whatever, madam, a order was passed. People find a page 15 with a direction to comply the order within a period of 6 months. That is reflected at page 20. Thereafter, madam, I filed an representation to the authority immediately on 12/12/2024. It was addressed to the commissioner, but not to a particular person, madam. Now, this was after having this representation, madam. Since the order, the commissioner was changed, transferred. So, madam, I again issued a demand notice at page number, madam, 23. The new incumbent, Chinmoy Prakash Upon. Thereafter, madam, since the order was not complied, I filed a madam contempt petition, madam. This contempt petition was closed, madam, on the ground that the application is premature. That the lordship will find at page 28.
Who received this document at page 17 of the contempt application? Who received this document at page 17 of the contempt application?
They have not received, madam. The contempt petition was closed. The contempt petition was closed, madam.
Kindly see the contempt petition, page 17.
Contempt petition number page 17 is different, madam. Seventeen is the order, madam.
Page 17 of the contempt application.
This was received by the commissioner. That's the
How do you
commissioner.
know? Is this the signature of the commissioner?
But this is the signature of the instrument dispersal where we receive, where we give the petition, madam. What's the kindly see the grounds, madam? It's number 9.
Who received this?
I have page 17. Well, this was
Kindly come to paragraph 6 of your petition,
after review, madam.
of your petition, contempt petition. Page 4.
Yes, madam. Yes. Oh,
I have page 6, paragraph 4.
page 6, paragraph number 4, madam.
Is the statement correct?
This statement is not correct to some extent, madam.
There is not,
But
it is not
partially it's
correct to
correct,
extent, no. Who accepted it?
But,
You say this is not the signature of the contemptor, of the commercial.
he will not receive.
No. Therefore, why you are making the statement out here that the commissioner, the respondents, the
Yes, sir.
contemptors, the concerned
Yes,
have
sir.
duly received the copy.
No, on behalf of the office, on behalf of the commissioner.
No, and issued and gave assurance. You say that,
Yes,
that,
it's a last.
no, we are now dismissing your contempt application to the leave which was granted is also on. I gave you the leave. That 1811, you still have time today. After 6 months, it will be duly taken out of.
Yes, madam.
And what is
But
this?
issue is that the other petitioners who approach this court, madam, after filing of this contempt case, madam, they have received the payment, madam.
You will get the payment. There is no quarrel with that. The fact that I have asked you that after 1811, 6 months is over, I'd say you can be. However, liberty is given to again approach the
Yes,
court
sir.
in the event no steps are being taken after 6 months.
That
So therefore,
that
you
I'm
come
satisfied.
again after it, after it.
Review, madam. We have had a review.
So, what is there to review? There is nothing to review.
Saying that since the contempt act, the special act, madam, and the section 20, which stipulates about a particular time. So, madam, this cannot be, I think, madam, from my view, madam, it cannot be extended, madam. You may also see the judgment, madam.
No, you see the order.
Yes, madam.
No,
That-
you
that I
see.
oblige, madam.
No, see the order of
Document is-
912. No, Mr. Counsel, kindly see the order of 912. 912 order says, accordingly in view of the above,
Yes, ma'am.
page 20
Yes, madam.
of the review petition. This court directs the respondents, more particularly the respondent, to pay the petitioner the executed quantity of work as measured in the concern in presence of the third party monitoring so and so in terms with the letter.
Yes, madam.
Exercise should be concluded and payment be made to the petitioner from
ma'am.
for the year within 6 months from the date of receipt of the certified copy of the order.
Yep.
So within 6 months from the date of certified copy of the order, I said that the period will not start from here. The period will start from 6 months is over from 1811.
Yes, madam.
Then,
They have not done anything, madam.
so we'll see when you file with a contempt application, come after 6 months. 1811, you have to come by May. Come after 18th of May and then come before this court. The liberty was duly given. I have not closed the entire thing. And you say that the contempt is dropped. The contempt has to be, no, the contempt is closed. I've closed the contempt with liberty. So you can very well come. So therefore, the question of review does not arise. You see, Mr. Das, you're Mr. Das, no? Yes. Mr. Das, kindly appreciate. When you are filing a contempt, I don't know, other courts may be very lenient in issuance of notice. I am not. You have to clearly make out a case of willful and deliberate violation prima facie. For violation, you have to categorically say, at paragraph number 4, you were not there, your junior was there on that day. At paragraph number 4, where you are saying that you are mentioning there are two contemners. One is the commissioner, one is the erstwhile commissioner. So both cannot be there. So your statement on the face of it is wrong. So the person who has received it, thereupon, after that, the moment it is done, you file after 18.5, we'll take care of it.
And only my question was that since the commissioners, they used to be transferred very frequently. So, it will,
Your statement has to be correct, Mr. Counsel.
but if you lots of kindly, I'm doing this case, but if you lots of kindly see at page 11, my grounds taken, and you haven't looked at it. It will not.
Where?
Page 11
Of
the review application.
Of the?
Review application. Page 11, madam. This is only madam,
Yes.
and events, madam.
Ah.
This is the point of the keep on changing, madam.
Ah.
So,
No, it's okay. There's no quarrel with that. It keeps on changing. But how, if you are saying that there are two contemners you are making, one is Megha Nidhi Dahal and the other is Chinmoy Prakash Pukon. These are the two contemners out there. When you are saying that one is the erstwhile, one is the present one, now, and you say that both the contemners have assured you, how is it possible? You come after 1811, we'll look into it. Not now. What's up?
Let me do this. Let me do this.
Mr. S.P. Das, the learned counsel appearing on behalf of the petitioner, submits that in the circumstance, within 6 months from the communication which was delivered, communication dated 17/11/2025, which was delivered on 18/11/2025, no steps are being taken for due compliance with the order dated 9/12/2024, the petitioner would approach this court by filing a fresh contempt application. First, this court also duly takes note of that such liberty was granted to the petitioner in the order dated 12, in the order dated 12/12/2025, passed in the accompanying, passed in contempt case number 653/2025. Accordingly, this court therefore does not find, this court therefore closes the instant review application in view of the said submission made by Mr. S.P. Das with a clarity, by clarifying that the closure of both the contempt application being contempt case number 653/2025 as well as the instant review application shall not preclude the petitioner to approach this court after 18/5/2026, if so advised. Why there are 4 petitions?
Into its for petitions, my lord, the private respondent filed the petition before the settlement officer in respect of only doc number 31, my lord. Accordingly, 28/5/2012 order has been passed in favor of the respondent. Thereafter, in 2018, my lord, the revenue board passed an order in respect of 31. But in the review case, my lord, in the review order, my lord, in addition to doc number 31, another 4-5 doc has been included in the review order, my lord. My lord, come to base 67, paragraph 10, my lord. Absolutely.
So they reviewed the order and passed they should have therefore, once they reviewed the order, they should have passed the order in the original matter.
Within the matter of land covered by doc number 31.
No.
But in the review, my lord, some other lands are also included.
No. Therefore, once they reviewed the order, which was passed on 28/12/2018,
Yes,
the appeal should have been taken up for hearing.
yes.
And thereupon should have been decided. That is the only point, short point, if I am not wrong.
Only thing is, my lord, that this Samsul and Mayhem, these two cases are different than the other two cases, my lord. In that case, the Board of Revenue passed the order, but here the Board of Revenue they're not the party here. But because they have to
No, this order is being passed by the Board of Revenue.
No,
FP
not
64.
not in this. The tag number is included, but not in this case because the settled petitioners are not applicant there, my lord, in the Board of Revenue. In this case,
No. These two orders,
Lordship-
we are concerned with 683 and 344.
344, yes, Board of Revenue passed the order. Lordship can take that matter, and what your lordship said that
Which
that order
one?
can be
Which one?
passed.
This one. Both are 7/1/2025.
Yes, but this
7/25.
but this case, they are not the party. Lordship will see that.
Huh?
They are not the party before the Board of Revenue. Neither
Who?
they have this petition, my lord. Samsul Haq. My lord,
You are not party before that.
no, they have to
No,
challenge the
no.
settlement officer order or circuit officer order. In this case, I am clarifying, my lord. My lord, come to this
Who filed the revision? What is your name?
revision file, my lord, on Kashmir.
Kasim Ali.
Kasim Ali and some others.
Kasim Ali is the here. How is Kasim Ali filing it? Kasim Ali is son was a party.
My lord,
Finally, come to page 42 of the WPC number 344. They are the sons of Kasim Ali.
they are the sons of Kashmir. Yes.
So Kasim Ali was a party.
yes. That is okay.
So Kasim Ali was a party. So therefore, this order was passed. As on that date, was Kasim Ali alive?
Kasim Ali was.
When did Kasim Ali die?
They have to say, my lord.
Huh? When did Kasim Ali die? You don't know when your father died. My goodness. Mr. Counsel, you are not prepared. We should vacate the interim order. No, you are not prepared. When did Kasim Ali die?
Well, if Kasim Ali is existing, well, if petitioner, here Kasim Ali is the petitioner, my lord.
Huh?
Yes, my lord. 3 down 4. Kasim Ali is the petitioner.
Kasim Ali is the petitioner.
Yes, my lord. Petitioner number 1.
Okay, Kasim
Kasim
Ali
Ali-
is the petitioner number 1. So
Yes.
they are parties here.
No,
Yes.
Kasim Ali is a party. I'm not disputing that part. But Samsul Haq is not a party here.
Who?
Samsul Haq. The petition number 683.
Okay. Why is Samsul Haq a party necessary to be made a party?
Because they filed writ petition, my lord, in view of their DAG number being included in that order, my lord. But they have to challenge the order of the circle officer, settlement officer, but they have not challenged.
Wait, wait, wait,
before the
wait,
court
wait,
is
wait,
written.
wait.
My lord,
Wait.
let me take the matter.
No, first tell me, who is Samsul Haq?
Samsul Haq and Rabial is the son of Shahar
No, Samsul Haq and Ferazul Haq.
Ferazul,
Who are they?
son of Shahar Ali.
And who is Sohar Ali?
Shahar Ali was the, my lord,
Was he a party to the earlier proceedings?
no.
Was he a party to the revision proceedings?
Oh, where, my lord, we are party.
Then
Because, my lord, that
then
is
why you are not approaching there?
Yes, no.
Why you are moving this court?
We are, our land has been included in the review order, my lord. No order has been passed against us except review order, my lord.
So therefore, you should have approached there, file a review.
Because, my lord, in the review, our land has been included, my lord. Initially, my lord, that is why I am saying, my lord, initially the case was initiated against only that number 31, my lord. Thereafter,
Let us see the first order which was passed.
yes, my lord.
Which is the main case? Samsul Kasim Ali.
Kasim Ali.
Sorry, Kasim Ali, my lord.
344.
Kasim Ali.
344 is the main case, my lord.
Main case, my lord.
Okay, what is the right of Kasim Ali?
Rayati, my lord.
Right, my lord.
He says, they said that they are the righties of the land.
So you are the righties of the land,
Yes.
Kasim Ali.
Kasim Ali and others.
And others means who others?
My lord,
Two others.
two others, my lord.
They are sons of Kasim Ali.
No, my lord.
They are who?
Lordship, we see
Kasim
the
Ali,
first-
Hamidur Rahman and Saha Alam Pradhani.
Yes.
Saha Alam Pradhani is the son of Kasim Ali.
Kasim Ali.
So all three of you were the riots
Yes.
under
Under the Tenancy Act 1971.
under
Under, my lord, initially the Prakritish Chandra Burwa was the Patata, my lord. Subsequently, the private respondent, my lord, included as a legal heir of Prakritish Chandra Burwa, my lord.
So you were the riotees under Prakotis Chandra Borua.
Yes, my lord.
Okay. Now
Yes.
let us see. Now tell me, where was your first name?
First name, my lord, page 28. Page 28.
What is this?
Page 28, my lord, Banda Kular, my lord.
Kotian number 20. And these are the name of the riots. Okay then.
Yes.
Now this is land of 12 bighas, 1 katha, 15 lechas. This is DAG number 27. Isn't it?
My lord, this letter is 344, my lord.
Ah,
344.
DAG number 27. Kindly come to page 28. Where is it?
27, yes, my lord.
DAG number 27.
27.
So in this land, these three persons, the petitioners, were the riots
Right.
under the heirs of Prakritish Chandra Borua. Okay, then what happened?
Then, my lord, the page 31, the land holding certificate was issued.
Ah. As a Khatian holder.
Yes.
Then what happened?
Then, my lord, page 32. The Rajti Khutiya,
Ah.
32,
No, it's okay. Then
32. This is the Rajti Khutiya, again, my lord, page 34.
then what happened?
Then, my lord, then, my lord, we have filed, my lord, additional affidavit, my lord, in that addition, actually come to page 72 onwards.
But this is Rayati Khotian number 77.
Yes, my lord, 77.
No, the order of 29/12/2018 is in respect to Rayati Khotian number 77. Whereas your Rayati Khotian is 80.
Yes, my lord.
Then
That is why I am telling my lord. My lord, right, writing a single number 77, and it's my lord, 4
and the Potta number is different.
repetition number 4,443, my lord.
Huh?
433, another customer and others cases. This is the main case, my lord.
I am looking into 344.
341, and another.
These are the persons.
Yes, my lord.
Now,
But-
therefore, my question is, this is dark number 27.
Yes,
And here the Rayati Khotian, this is dark number 31 is for 29/12/2018.
this is the repetition 443,
Ah,
443, my lord.
344.
443.
443. What is that? This is
the
another
main
case.
This is the main case, my lord, tag number 31. And the 3 repetition, my lord, those tag number are included in the review order, my lord. No proceeding was initiated against those 3 tags, my lord.
No.
Yes.
Qasim Ali filed a case of revision before the Board of Revenue. That is case number 99 RA Dibrugarh 2018. Against some order dated 17/4/2012. Mr. Counsel, you are not prepared?
28. My lord. The 99 are here.
We are looking into 344. Don't look into all other papers. 344, you look into it. There is an order of 17/4/2012. Where is that?
That we have imposed in our affidavit in opposition, my lord. This is the additional affidavit, my lord. Yes, 51.
Huh?
Yes, 51, additional affidavit.
Where? Page 51 of what?
Additional affidavit. Filed by the petitioner.
17/4. This is a prayer for deleting.
This is the prayer made by the private respondent, my lord.
And where's the order?
And my lord, there is no 17/4/12 order, my lord, in the body of the petition was written, my lord, page 53.
Huh?
Body of the petition, it was written, my lord, page 53. ASO Gologon Circle, please take necessary as per rule. Then, my lord, page 54. The case was registered, my lord, 6 of 2012-2013 by the Assistant Settlement Officer Gologons, 17/4/2012.
So this is dark number 31.
This is doc number 31.
So this is dark number 31, the order of 17/4/2012,
Yes.
whereby these names were so and so. Accordingly, the miscase has been registered and ordered to serve notice and the opposite parties, and also directed the concerned Mondal to visit the so and so as per the order of the assistant officer. So this is an order of 17/4/2012.
Yes. Then,
Okay.
page 55, 28/5/2012.
So it
This
is
is
ordered to
the
cancel the name of the
final order.
pattadas recorded in the resettlement operation so and so, and the name of Qasim Ali, Nur Jamal, so and so from the land of the suit of dark number 24 bigas so and append the name of the wool pattada so and so. Okay. Now this is the order of 15
28/5/2012.
28/5/2012
And this order was challenged before the Board of Revenue, my lord,
in
in RA 99.
99.
Yes, my lord.
RA 99 says, yes, order of
Yeah.
so and so. Okay.
29.
Now this is for Dark number 31, KM Patna number 79, Rayati Khotian number 77.
7.
Now, where is this particular document of your Rayati Khotian?
77. This is the repetition by the Chabal putting.
Okay, let us read. So this is dark number 31.
31.
So this was a case being filed for debt.
Yes.
Okay, now what has happened?
Then, my lord,
So and so heard the learned advocates for the petitioner as well as the learned appearing for the respondents. After hearing learning submits that the impugned orders have been passed behind the back and so and so. Hearing the parties and going through the documents, I am of the considered view that the impugned order has been passed ex parte behind the back or without issuance of notice and so has been cancelled. But in the instance of objections given by the so and so in view of the legal position of the hand, Union with the impugned order dated so and so passed by our legal and granted accordingly, then proceed to orders are hereby set aside and to be hereby ordered the circle officers shall restore the Khotian number 77 as well as the name of the petitioners in the year. So this is being given for dark number 31. So this is for dark number 31. Okay, now what has happened? Then then an application was filed under section 7 before the Assam Board of Revenue. Now, Board of Revenue, the ex parte order passed by in the revision so and so. Allow the revision before. So this was also passed ex parte.
Yes. 29/12/2018 also expert.
Ex parte. So you got a favorable order ex parte. He got a favorable order ex parte.
Yes.
So minus plus.
But in our case, we have, in their case, no notice was sent to us. And neither we made party in that case, my lord. And in their case, they have received the notice, they filed Vakalatnama, then they took time to file WS, but they could not file, then the Board of Revenue has passed the order.
Now your question is, the proceedings for 29/12/2018, or for that matter, the proceedings of which led to 28/5/2012 was in respect to dark number 31. But they have included various other darks which was not the subject matter. That is your case in all the petitions.
So, yes, other 3 matters, this is the subject matter of question, my lord, and in this case, my lord, although the review court, my lord, allowed the review, my lord, after allowing the review, my lord, they have not heard the original case, my lord, original 99.
That I know. So 99 ought to have been heard. So, and 99 was only in respect to dark number 31, which required to be heard. There was no petition filed in respect to the other darks of 27, 29, 30, 40, and 302.
Yes, my lord.
Did you file any application for that?
In the review, we have filed
Review? How can you go?
no, they are.
So therefore, this order is
Yes.
palpably wrong.
Yes.
So we therefore set aside this thing and permit the and direct the authorities to the Assam Board of Revenue to hear the review order, the revision petition afresh, which is filed by them.
That is actually correct law, madam.
Yes. So they let them be filed afresh, but the other dark numbers could not have been a part of it.
But yes,
Unless you file an application for removing. It is a fact that you have not asked for the other year.
in the review, we have.
Again,
but not in the main.
review you cannot.
Yeah.
You have to go from down.
Right,
huh?
right.
So your case is that you have only asked for 31. Did you file any application for the other DAGs before the settlement officer?
Yes, we filed it. That is in the review. Yes, we have filed before the assistant settlement officer.
Where?
Yeah, Lordship may come to our affidavit opposition page 87.
Huh?
87. Initially, it's a entire 48 bigha has been involved in this case.
This is doc number 77, this is the doc number 31. This is doc number 31. Where have you filed for others? And all emanates from that order only.
Yes.
You see, 99 RA B, RA Dibrugarh is only in connection with 28/5/2012.
Yes.
So therefore, 28/5/2012 passed in miss case number 6/2012 to desk 13 only is in respect of doc number 12, the 31. So others could not have been a part in a review order. Heard. Anything? Government?
Only
Would
my
they
lord,
say later on
the
they want
state
to-
has filed affidavit. State has filed affidavit.
Forget about state. State filing in. But the fact remains, in a review order, how can you bring something else which is not a part of it? Unless you show me that you see, you have sought for review of an order passed in 99. Did you seek a review for any other order?
No.
So 99. 99 is only in respect to doc number 31.
31.
So nothing. has been-
31 consists of my lord, total 24 bigas.
Yes, understood. That is understood. That I understand. Level. You are appearing for everybody?
Senior counsel solicitor purpose
Oh.
yes. But is like mother is in the cat matter.
Oh, who is the senior counsel?
Yes, doctor.
There, number 2.
No, my lord.
Huh?
Yes. That is why.
Should we dismiss for default?
No, my lord. I prefer it, but my lord, his name may be shown, my lord.
Why should I show his name? First of all, I don't show it when the senior counsel appears. And you want that the senior counsel's name has to be shown.
Yesterday also he was, I think, better.
Huh?
Yesterday also, I think, better.
Okay, then we wait for the senior counsel. We vacate the interim order. Okay, we vacate the interim order and wait for senior counsel to be listed after the registry you file an application. Okay? Don't come up with this type of thing.
My lord, only one thing that
Mr. Counsel, I'm telling you, this is a very dishonest argument you are making. It is. A senior counsel being not present out here, you are asking this court to record the name of a senior counsel. Huh? Do you know what the submission you are making? This court can very well refer this aspect to the full court for striking, for taking away the gown of the senior counsel. Be careful. Don't make this type of submission for me. Okay, Leho.
only one thing is whether after the proceeding manner, in respect of all the dark matter, we filed a petition before the deputy commissioner, my lord. That is pending. It's page number 203, my lord. But
That is
only
different.
after
We are
that,
not concerned.
after that.
Here we are concerned only a challenge is made to the review order. Have you challenged any other order
No, my lord.
in all the cases?
All the yes, sir.
Only the same review order.
Yeah.
Heard, mister? Your name?
Yeah, sir.
M. Hussain. The learned counsel appearing on behalf of the petitioner. Mr. J. Hendick appears on behalf of the Revenue Department. Ms. Udas appears on behalf of the respondent number, on behalf of the district commission, appears on behalf of the respondent number 1. Ms. Udas appears for respondent number 2, 3, and 2, 3, 4, 5. 6. Mr. J. Roy, the
7 to 11.
senior counsel, assisted by so and so, appears on behalf of the respondent numbers 7 to 12.
Good.
In all the writ petitions. Same, hearing parties are same.
Only 2 cases are different, my lord.
Parties are same.
Same.
The 4 writ petitions which have been filed, which are presently taken up for adjudication by this common judgment and order, taken up for disposal by this common judgment and order, assails the order dated 7/1/2025, passed by the chairman, passed by the Assam Board of Revenue in 5 RA bracket DBR bracket close bracket R open bracket open RBW bracket close oblique 2022. The petitioners in WPC number 344 oblique 2025 and WPC number 443 oblique 2025 are the Khotiandars of various plots of land. The petitioners, the said petitioners, have been issued a Khotian number 80 over a land at measuring 12 bighas, 1 katha, 15 lechas, covered by dag number 27 of patta number 79 under village Humardaha, part 2, within revenue Golokganj revenue circle in the district of Dhubri or Kokrajhar? Dhubri, Assam. Now? This was earlier, na? The petitioner, the said petitioners have also been issued a Khotian being Khotian number 77 over a plot at measuring 24 bighas, 2 katha, 5 lechas, covered by dag number 31 of patta number 79 within village of village Dhumdhara part 2 under revenue circle Golokganj in the district of Dhubri, Assam. It is submitted by Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner, that presently the revenue circle in respect to those khatiyans which were issued to these petitioners falls within Karimganj, Goripur revenue circle. The petitioner in WPC number 683/2025 petitioners in WPC number 683/2025 have been issued a Khotian number 60 over a plot of land measuring 3 bighas, 1 katha, 15 lechas, covered by tag number 28 under KP Pata number 79 of village Dhumdhara Part 2 under Moza Golagganj revenue circle. Moza is also Golagganj. Under Moza Golagganj in the district of Dhubri, Assam.
Sorry to mention, madam. In this case, madam, the Sohrali was the Rajika, the father of the petitioner.
Huh?
Father of the petitioner is the Rajika. Yes, 45.
The writ petitioner in WPC number 678/2025 is the son of one
683, madam.
678.
678 is the Pataka.
How is the Patadar?
Madam passes the land, madam, on the basis of stated from the right.
Huh?
Yeah.
No, this is a Patta number. This is also a Patta. Where the Khotian?
Yes. He passes the land, madam.
678, where is the Patta? Khotian. Huh?
Yes, 36, madam.
Where is the Khotian number? Where? What is the Khotian number?
He projected Khatian number 77 in it's 678.
Where? Page?
Here number 80, madam, page 37.
Khotian number is where?
Page. That number.
But his case is not, my lord. This is a case that he purchased the land, my lord. From the Khatiandar, my lord.
From the Khatiandar, madam.
That is impossible, my lord. This case is different, my lord. And he
Okay.
could not have filed a, he's not even the, appeared before the Board of Revenue.
It's okay. But he has purchased from the Khotiandar.
Yes,
And Khatiandar,
And the Khotiandar's Patta number is what? 40.
40, my lord. 40, old. 40, my lord, 40, dag number 40. Previously, it was 163,
The
274.
petitioner in WBC number 678/2025 have purchased the land from the Khotiandar.
I think, not Khatiandar also. I think son of the Khatiandar, my lord. Not even Khatiandar.
Okay, from the son of the Khotiandar. At measuring 1 bigha, 2 katha, 17 lectures. Are you sure?
yes.
1 bigger 2 kata 70 lectures.
17 lectures. Which was held by the under Khutian number 19 of Dag number 40. Under Miyadi, under Khiraj Patta number 79 of village Dhumdhara part 2. In the district of Bolagganj, within the revenue circle, within the Bolagganj revenue circle, in the district of Dhubri. So which are the dark numbers we are concerned? One is 31.
One is 40, my lord.
One is 40. One is 28. And the other is 19. No. Another one is 31, 40, 28, and
27.
27. Okay. 27. It has been submitted by Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner, that all these lands are presently within the Goripur revenue circle. The records reveal that the private respondents filed an application before the settlement officer Dhubri on 17/4/2012, which was registered as miss case number 6/2012-13, seeking deletion of the name of the Pattada and the Rayati recorded in the survey record and correct the survey records. A perusal of the said application, which is annexure A to the additional affidavit filed by the petitioner in WPC number 344/2025, would show that the private respondent sought the deletion of the names of one Joyshri Gogoi and one Subhashri Gogoi, whose names have been shown as Patadas, and the names of the petitioners in WPC number 344/2025 and 443/2025. The said application further mentions the land in which, wherein such deletion was sought for, that is, land at measuring 24 bighas 2 kata 5 lechas, covered by dag number 2/163 old, 31 new, under village Daha part 2, which was covered by Riotic Hatian number 77. Pursuant to the said application, a proceedings was initiated by the Assistant Settlement Officer, Golagganj Revenue Circle, by passing an order on 17/4/2012. On 28/5/2012, the Assistant Settlement Officer disposed of the miss case number 6/2012-13, thereby striking out the names of the Patadas, namely Sri Joyashree Gogoi and Sri Subhashree Gogoi, as well as the names of the petitioners in WPC number 344/2025 and WPC number 443/2025, insofar as the land measuring 24 bighas, 2 kathas, 4 lechas covered by Khotian number 77, tag number 2/163, oblique bracket old oblique 31 new of village Dhumadhara part 2, and upheld the names of the private respondents. The petitioners in WPC number 443/2025 both are same, na?
443 and
344. The petitioners in WPC number 443/2025 challenged the said order dated 28/5/2000, the orders dated 17/4/2012 passed by the settlement officer Dhubri, and the order dated 28/5/2012 passed by the assistant settlement officer Golagganj Dhubri in miss case number 6/2012-2013 before the learned Assam Board of Revenue, which was registered and numbered as case number case number 99 RA bracket DBR/2018. The learned Assam Board of Revenue passed an ex parte order, thereby setting aside the order dated 17/4/2012 passed by the settlement officer Dhubri, as well as the order dated 28/5/2012 passed by the assistant settlement officer Golagganj Dhubri in miss case number 6/2012-13, and further directed the circle officer Goripur Revenue Circle Dhubri to restore the Khatian number 77 as well as the names of the petitioners in in case number 99 RA bracket DBR/2018 in the relevant record of rights of the land in question forthwith, causing necessary correction of the relevant records of the said land.
There we are not made party, madam. In this case, we are not made parties. Only settlement officer and assistant settlement officer was made party. We are not.
It may not be out of place to mention that the said order which was passed by the learned Assam Board of Revenue, it is relevant to mention that the case which was being filed by the petitioners in WPC number by the petitioners before the learned Assam Board of Revenue and registered as case number 99 RA bracket DBR/2018. The petitioner, the private respondents herein were not arrayed as parties.
And one more thing, my lord. They filed the application on 21/12/2018 and order was passed on 29/12 next day.
That is okay. We also know, I also know. The private respondents herein, being aggrieved, filed a review petition under Section 7 of the Assam Board of Revenue Act 1962 before the Learned Assam Board of Revenue, which was registered and numbered as 5 RA bracket DBR bracket close R bracket open RVW bracket close oblique 2022, challenging the order dated 29/12/2018 passed in '99 RA bracket DBR oblique 2018. The Learned Assam Board of Revenue not only set aside the order dated 29/12/2018, passed in the revision petition number 99 RA bracket DBR oblique 2018, but also directed restoring the original pattadas as on 18/12/2018. Restore and also directed that the land record shall be restored to the original pattadas as on 18/12/2018 in respect to the land measuring 48 bighas, 0 kotha, 13 lechas under dag number 27, 28, 29, 30, 31, 40 and 302 in KP Patta number 79 of village Dhumdara, part 2, Moza Gauripur, Revenue Circle Gauripur in the district of Dhubri, Assam. It is under such circumstances the present 4 petitions have been filed. First, the grievance of the petitioner in WPC number 683 and 678 oblique 2068, the petitioners in WPC number 683 oblique 2025 and 678 oblique 2025 are that they are the Khotian holders of DAGs numbers 28 and 40, which was never the subject matter before the Learned Assam Board of Revenue or even the settlement officer in Miss Case number 6 oblique 2012 of dash 2013. And therefore, in exercise of the review jurisdiction, their rights could not be affected by the Assam Board of Revenue. That too without issuance of any notice. You are going to write the judgment? The case of the petitioners in WPC number 344 oblique 2025 is that the proceedings in Miss Case number 6 oblique 2013-14 12-13 relates to tag number 31, whereas tag number 31, and thereupon proceedings was taken up before the learned Assam Board of Revenue, which also related only to tag number 31. However, in the review order, the learned Assam Board of Revenue included tag number 27, which was not a part of the original proceedings, and which was never the case before the never the case of the private respondents before the settlement officer or the assistant settlement officer, as the case may be. Insofar as the writ petitioner in the WBC number 443/2025 is concerned, the learned counsel appearing on behalf of the petitioner submitted that the said order, which was the impugned order of review dated 7/1/2025, was passed ex parte without giving an opportunity of hearing to the petitioners in the said proceedings. It is the further case of the petitioner that is not ex parte, no?
Heard both the parties.
But the original case has not been.
What?
After review, the original case has not heard.
As regards the case of the petitioner in WPC number 443/2025, it is the case, it is submitted by the learned counsel appearing on behalf of the petitioner that once the review application was allowed, the order dated 29/12/2018 could have been recalled. But the revision petition thereupon ought to have been heard, which was not done by the learned Assam Board of Revenue. And it is under such circumstances the impugned order is required to be interfered with. Full stop. The learned counsel appearing on behalf of the petitioner further submitted that merely because of the order dated 29/12/2018 passed in revision petition number 99 RA bracket DBR/2018 is wrong, is incorrect or not tenable, cannot be a ground to reject the revision petition filed by the petitioners. Without deciding as to whether the order dated 17/28/5/2012 was in accordance with law. Hey, Noksun, where's Ulisha? I've heard Mr. J. Roy, the learned senior counsel, appearing on behalf of the respondents, private respondents who submitted, that the names of the petitioners in respect to all the DADs which were referred to in the review in the impugned order dated 7/1/2025 were inserted without following the proper procedure, and as such there was no mistake on the part of the learned Assam Board of Revenue in passing the order dated 7/1/2025. The learned senior counsel, however, with all fairness, had submitted that the initial proceedings were only in respect to dag number 31, but the review order related to all the various other dags, that is dag number 27, 28, 29, 30, 40 and 302 of KP Patra number 79, which had submitted that the proceedings in Mizze case number 6/2012/13 was in respect to only dag number 31 and not dag number 27, 28, 29, 30, 40 and 302 of KP Patra number 79. The learned senior counsel, however, submitted that taking into account that the Assam Board of Revenue, learned Assam Board of Revenue exercises supervisory jurisdiction under Regulation 151 of the Assam Land and Revenue Regulation 1886, the learned Assam Board of Revenue was justified in passing the impugned order dated 7/1/2025. Anything more?
Madam, we have disputed their Khatian and other things, my lord.
Understood. That too, I would first put it that their names have been incorrectly entered. That I have put it. Secondly, as regards this, you admit that 31 was only the proceedings. Third, you say that 151 supervisory jurisdiction, they can do it. Anything more?
Nothing, if your lordship remand the matter, then should be here on merit and
But for the other dogs, it has to be done in accordance with law. Not by this way.
but in respect of
Other dogs, you can't touch it unless you proceed as per law.
we have already, anyway.
That's a different
Yes.
case. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the narration of the facts, it is apparent that the petitioners in the 4 petitions claims right on the basis of certain Khatians being issued in their favor or through the Khatian holders. The proceedings which was initiated by the private respondents herein before the settlement officer, Golakganj Revenue Circle, was the proceedings for deletion of names of certain pataras as well as the righty holders whose names appeared in the record of rights. In respect to dag number 31 of KP Patra number 79, the said application is absolutely clear, details of which this court have already referred to here in above. This court also finds the order dated 28/5/2012 passed by the Assistant Settlement Officer, Golakganj Revenue Circle, wherein the names of the petitioners in WPC number 443/2025 was struck off, along with the names of 2 patadas, only in respect to dag number 31 of KP Patra number 79. The said order and nowhere mentioned about DAG number 27, 28, 29, 30, 40, and 302 of KP Patra number 79. The revision petition which was being filed by the petitioners in WPC number 443/2025 after 6 years before the learned Assam Board of Revenue was filed in terms with section 151 of the Assam Board of Assam Land and Revenue Regulation 1886. Challenging the orders dated 17/4/2012 and 28/5/2012. It is surprising to take note of that the said revision application which was filed and registered as 99 RA bracket DBR bracket close 2018 was filed on 28/12/2018. And on the very next date, the learned Assam Board of Revenue allowed the said application even without giving an opportunity of hearing to the private respondents. It surprises this court at this stage to observe that when the supervisory jurisdiction is being exercised under 151, the learned Assam Board of Revenue, that too after a hiatus of 6 years, the learned Assam Board of Revenue at least ought to have at least issued the notice to the persons who would have been affected. So said order dated 29/12/2018, therefore, on the face of it, was arbitrary and violated the very principles of natural justice. The private respondents thereupon have filed a review before the learned Assam Board of Revenue, which was registered and numbered as RA bracket 5/2000 RA bracket DBR RVW/2022. The learned, this court had perused the order dated 7/1/2025. And in the opinion of this court, the recalling of the order passed by the learned trial court, passed by the learned Assam Board of Revenue dated 29/12/2018 was duly justified, as there was an error apparent on the face of the record. However, the review jurisdiction could not have been exercised by the learned Assam Board of Revenue to the extent of bringing within its, of passing certain orders which was beyond the scope of the original proceedings. This court observes, in view of the fact that the proceedings which was initiated, being Miss Case number 6/2012-13, was in respect to DAG number 31 of Patra number 79. However, the learned Assam Board of Revenue, Patra number 79, in respect to a plot of land at measuring 24 bighas, two gathas for 7 lectures. Whereas the learned Assam Board of Revenue, in its review while exercising the review jurisdiction, dealt with a plot of land at measuring 48 bighas, 0 katha, 13 lectures, which was not only being covered by DAG number 31, but also by DAG number 27, 28, 29, 30, 40, and 302 of KP Patra number 79. This was completely beyond the jurisdiction, beyond the scope of the review jurisdiction. Accordingly, it is therefore the opinion of this court that the impugned order dated 7/1/2025 passed by the learned Assam Board of Revenue in RA number so-and-so, 5 RA number so-and-so, is required to be interfered with partly. Accordingly, the writ petitions stands disposed of with the following observations and directions. And it requests to be interfered with. First, the impugned order dated 7/1/2025 passed in RA number 5 oblique so-and-so by the learned Assam Board of Revenue is partly interfered with insofar as the directions were issued to restore to the original pattadas, that is the private respondents herein, as on 18/12/2018, in respect to the land at measuring 48 bighas, 0 katha, 13 lectures under DAG number 27, 28, 29, 30, 31, 40, and 302 in KP Patra number 79 of village Dhumdara, part 2, Moza, Gauripur, Revenue Circle in the Gauripur, in the district of Dhubri, Assam. The impugned order dated 7/1/2025 passed in RA 5 oblique so-and-so to the extent of reviewing the order dated 29/12/2018 passed in revision petition number 99 RA DBR oblique 2018. Is not interfered with. This court further observes and directs that upon reviewing the order dated 29/12/2018 passed in review jurisdiction revision petition numbers 99 RA DBR oblique 2018, there was a requirement on the part of the review learned Assam Board of Revenue to decide afresh the revision petition number 99 RA DBR oblique 2018. By giving due opportunity of hearing to all the parties. Accordingly, this court therefore directs the learned Assam Board of Revenue to decide afresh revision petition number 99 RA oblique DBR oblique 2018. Afresh by giving due opportunity to the parties to place their cases. It is further observed, for the sake of clarity, this court observes that a revision petition number 99 RA DBR oblique 2018 shall be restricted only to the land covered by Dag number 31 of KP Patta number 79 of village Dhumdara Part 2, Moza, Gauripur, under Gauripur Revenue Circle in the district of Dhubri, Assam, and would have no relation in respect to Dag number 27, 28, 29, 30, 40, 302 of KP Patta number 79. The petitioners in WPC number. Record has come, no, na? The petitioner in WPC number 443 of 2025, as well as the private respondents in the instant proceedings, are directed to appear before the learned Assam Board of Revenue on 15th of May 2025 for further progress of the revision petition number 99 RA DBR oblique 2018. There shall be no order as deposit. In time orders, if any, can be the present order, however, this court further, before parting with the record, this court, however, makes it clear that the present order, however, shall not preclude the private respondents to shall not affect or prejudice or preclude the private respondents to initiate steps before the concerned authorities in respect to the Dag numbers. Hey, Bakita Dagna 31 to by if so advised.
Obliged.
So you have more cases then. Then you can engage Mr. S. Datta.
Before my learned friend start, my lord, these are the 7 numbers of item. There are 7 numbers of identical in nature. The matter pertain to non-payment of the contractual bill. Now, lordship, in out of this 6 items, we have already filed our affidavit in the opposition. But lordship, only on record, there 3 affidavits come up on record. 2 are still, my lord, not part of the record.
What is your affidavit say?
My lord, affidavit, we have admitted the liability.
Then payment, make the payment within 6
my lord, our responsibility only to get the purchase. The payment has to be made by the directorate office. They will hand it over the fund to us. Then
Who will pay?
Directorate office, my lord. They have to arrange the fund and they have to arrange the fund.
Who has to pay?
Director of Agriculture.
Who gave the contract?
My lord, he has given the contract.
We have given the contract, and based on that, my lord, they have made the supply. But so far the fund is concerned, that has to be made arrangement by the Directorate of Agriculture, my lord.
May I submit, my lord?
Yes, Ms. Jigora. Meet it. You have a copy? Which other items?
Item number 32, my lord. 29, 30, 32, 34.
My lord, in item number 29, we have not filed our affidavit.
I don't require affidavits. 30,
29, 30, 32, 34,
32,
44,
32,
52 and 60, my lord.
34,
yes, 44,
35,
No, my lord, not 30.
35, 31, different happen. 44,
44,
yes, my lord.
and
52,
And 60, my lord.
and supplementary 61. All in this letter, amount has been admitted by them, my lord.
amounts have been admitted.
Yes, my lord.
My lord, except 29 till yet, my lord, we have not filed.
Why?
No, my lord.
I think
They see filed the affidavit.
were admitted, pay within 6 months. Direction given to the AR to provide the funds
Well.
to the direction to the government. AR is admitted, and as such, the petitioner is entitled to the said amount. Amount given to us, amount given to the petitioner is entitled so and so. The amount is to be disbursed by them to him. amount will be disbursed by the Directorate of Agriculture. The Ministry, the Department of Agriculture. By the Director of Agriculture to the Seeds Corporation of India, and the Seed Corporation thereupon shall release the said amount to the petitioners. The said exercise be completed within 6 months.
Well,
All this was.
For some more time,
What is it matter about?
madam, regarding madam payment of the madam
Which payment?
vehicle madam bolero madam.
Huh?
Amount is madam 6,34,664 madam, but we could not get the necessary instruction madam. I have received a letter because of madam that election and as well as they are to madam collect some information.
Petitioner, Senior Government Advocate appearing on behalf of the respondent number 1, 3, 4, 5, 6, and 7 submits that some more time is required to verify the claims of the petitioner and place the same before the court. Accordingly, list this matter again on 18th of May 2026. On the next date, the respondents shall ensure that the details as to whether the petitioner is entitled to the amount so claimed or any other amount be placed before the court.
33 also similar, same. 33 also same.
And they said, my lord, there is some rule, my lord. On the basis of rule, I am not entitled for this. Day before yesterday, they find the affidavit. I want to find a reply back. Because as per agreement, my lord, I have executed the work with the deputy commissioner. Last time, deputy my lord produced some, my lord, instruction, but today I don't know that amount has been admitted. In fact, document has itself shows the amount has been admitted. Now they have taken, my lord, that as per, my lord, their rule, my lord, they have specifically stated that I am not entitled for 136 rupees. I am entitled for 100 rupees, my lord. And I have gone to the document, my lord, as per central government.
You are?
My lord.
Who are you?
I am the contractor, my lord.
Contractor for what?
Contractor for transporting the goods, my lord, food grains, my lord.
There was another matter which I was taking up, filed by Mr. D.J. Das. What has happened to that matter? There they speak, the government has been issuing doing a particular thing. They are giving 100 rupees here and 36 rupees they are appropriating and giving it to the cooperative society. This must be the thing which they are doing.
Yes.
So what happened to that matter? I passed a long order in that matter and the matter never came up before me thereafter. Because here it is the government who have brought the cooperative society inside. But the rules do not say that a cooperative society can be brought within. You are an agency, authorized agency.
Yes, my lord. I have taken goods, my lord.
Are you the authorized agency or not?
Yes, my lord. Agreement has been executed with me, my lord. Order was issued to Annexer 1, Annexer 2.
And as per the agreement, how much you enter?
136.
Then
That is the reason, my lord.
that
Yes,
you cannot.
And if your lordship go to their document, my lord, it is my lord, 43, my lord.
Huh?
43, my lord. As agreement, I first saw your lordship the agreement, my lord. It's 25. This is the agreement between me and Deputy Commissioner, my lord. And that has been fixed 136 rupees, page 20, second page. Second page.
But why are you carrying on this business of transportation?
My lord,
How are you carrying on this business of transportation?
your lordship, work order has been issued, annexure one.
No. You see, when you see this particular document as a food grains thing, this can be done only by the rules. This is seven. So that is for the margin. For transportation,
There is a tier one, tier two transportation, my lord.
Two-tier system.
Come down, my lord. Go down, my lord. Come down, my lord.
where is the rules, proper rules?
Lordship, our affidavit page 62, Bharat. The food security assistance to state government was 2015.
On National Food Security. National Food Security Act. Commissioner COVID-19 Commissioner. So here the central government will pay 100.
My
And what about the others?
other will be paid by the state, my lord.
And why you're not paying?
My lord may be placed to because of my lord COVID-19 only, my lordship will see the page 68 of annexure 2, my lord, that office memorandum was issued in our affidavit, lordship. Issued, my lord, Pradhan Mantri Garib Kalyan Anna Yojana, the additional allocation of food grain to all the beneficiaries, my lord, covered under targeted public distribution system. We have paused for a period of 3 months, my lord. So this has been enhanced, my lord, during that period only, my lord.
What?
The additional amount, my lord, lordship, my reply page 51, paragraph 6, my lord, that page 51, paragraph 6, that prior to April 2020, before the outbreaking of COVID-19, in the scheme of NFSA 13.
No, we are not concerned with
My lord.
FSA or so and so. Kindly
My lord.
come to, madam, kindly come to 7-9.
Earlier, my lord,
Page 64, page 64.
yes, my lord.
For expenditure on interstate movement and
My lord.
handling of assistance, central government shall assistance shall be limited to the rate specified. Rate specified is 100. If
My-
it's special.
My lord.
Or the actual average rates for the state as a whole, at which the expenditure was incurred by the state government, whichever is lower.
No.
So the central government will pay 100 rupees, or if it is 50 rupees, 50 rupees, whatever may be. But if it goes above, it is your duty.
My lord, my paragraph 6, lordship, page 51. That amount is, my lord, the transporter in the state rupees 100 per quintal, wherein central share is 75 and state share is 25, my lord.
Where?
Page 51.
51.
51 of my affidavit, lordship.
Yes.
Paragraph 6. There
Prior
we
to
have stated.
COVID, the approved rate for transportation of handling of so and so in the state was rupees 100 per quintal, wherein the central share was 75 and 25 was shared by the state.
My lord.
In addition to that, the state government decided to pay a sum of rupees, additional amount to the transporter of 36 rupees,
And
50 rupees per quintal, depending on the terrain and so and so.
My lord.
Then,
My lord, office by additional allocation of food grain to the beneficiary covered.
we are concerned with which period, madam?
Concern, my lord, this after 2020.
These are
March
later on.
2020.
These are
After-
later on.
Yes, my
Here
lord,
the
later on.
period is at page 58 is of the year 2022.
This,
No
this-
COVID.
as per the affidavit, my lord, this enhancement was made only during that period, my lord. It was not enhanced after that, my lord.
No, we are not concerned. You have a contract.
Contract with by this affidavit has been filed by the, my lord, commissioner. The contract was, my lord, we'll have to file affidavit by the DC also because
DC has
DC
admitted the
has admitted.
Last
It
time
is
police-
contract between DC, my
this
lord.
instruction. He has admitted the amount.
But-
See, is he going to pay from the pocket?
And that, my lord, because commissioner is saying that after, my lord, COVID-19, my lord,
You
it
should
was
have
not
asked.
enhanced,
That we are not going to give it.
my lord,
You are now, you see, earlier it was
Not-
75, 25.
my lord,
But with these amendments which have been made, 7-1 was brought in.
my lord.
7-1 now has made it in the special terrain, it's 100 rupees. So 100 rupees you are going to get it. Now you are not going to spend a single penny from your own pocket. And you are saying that the state government is providing funds. The food is being provided by the central government.
My lord.
100 rupees additional central government. 143 rupees to the food fair price shop, central government.
Right.
17 rupees for the E2S, central government. What is the state doing?
My lord, I may be allowed some time to file affidavit by the deputy commissioner, my lord. Or he can, instruction is here, my lord. Instruction is here. That admitted, my lord, that DC has admitted the amount.
136.
But my lord, commissioner is, my lord, disputing that this enhanced amount was only made during the period of COVID-19, my lord.
Anyway, let him file an affidavit in reply.
Lordship.
Don't you think so?
My lord.
Yes, because the DC, how is the DC's affidavit you file it
I'll file, my lord. I'll file, my lord.
and get hold of another counsel to appear the commissioner and the DC separately?
My
No,
lord,
no, because the one person cannot
Yes,
appear for
Yes,
both.
my lord, controverting, my lord,
Ah.
yes, my lord, it's not, DC has admitted and my lord, now commissioner is, I'll,
An affidavit has been filed on behalf of the respondent number one, wherein it is being mentioned that the petitioner's entitlement is rupees 100 per metric ton for the transportation of the food grains. On the other hand, the petitioner have entered into a contract with the deputy commissioner, which one?
Annexer, my lord.
Deputy commissioner,
Deputy Bongaigaon.
Bongaigaon, wherein the terms and conditions specifically stipulated that the amount to be paid per metric ton is rupees 136. The respondent number one had relied upon the Food Security Assistance to State Government Rules 2015. And on the basis thereof said that the central government share is only rupees 100. So the question therefore arises as to whether the state would be liable to pay for the additional 36 rupees per metric ton, taking into account that the rules of 2005-15 or any of the provisions of the National Food Security Act 2013 do not bar the additional component to be paid by the state government. In this regard, this court finds it pertinent. In this regard, Mr. N.B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner would also like to file an affidavit in reply. It has also been brought to the attention of this court during the course of the hearing by Ms. Yudas that the Deputy Commissioner, Bongaigaon, however, have admitted to the claim of the petitioner. An affidavit by the Deputy Commissioner also in that regard would be essential. Accordingly, this matter again on 22nd of May 2026. In the meantime, the Deputy Commissioner Bongaigaon is directed to bring on record its stand by filing the affidavit. The petitioner also would be at liberty to bring on record its reply by filing the affidavit on or before the next date.
One metric ton, it should be like a per quintal. Well, 156 is per quintal, not metric.
Quintal.
The approval was given on the day was changed. They given Tuesday instead of Friday.
You don't like Tuesday.
Since 2013, and our cattle market on Friday.
Who is having it on Friday?
It was given to
Friday, why are you busy with selling cattle and all instead of that being there in the mosque? Friday is the holy day.
that petition. It's already taken up on the in the year 2014, another repetition. Page 30 or also pennies.
Anyways,
We want to file
you
affidavit.
huh?
We want to file affidavit, my lord. So 4 weeks time may be granted.
Already status quo was back.
Yes.
You're running.
Yes.
You? You like to file a affidavit? You have filed the affidavit in opposition.
They have already filed, yes. I want to file this.
Mr. S. Gupta, the learned standing counsel of the PNRD department submits that he would like to file an affidavit, that the PNRD department would like to file an affidavit in reply. Affidavit in opposition. This matter again on 10th of June 2026. In the meantime, the affidavit in opposition be filed on or before 1st of June 2026. Liberty given to the petitioner to file reply against the affidavit in opposition filed by the respondent number 9, as well as the petitioner, respondent PNRD department on or before the next date. The interim order passed earlier shall continue till the next.
Your in fact, item 39, that is also same, my lord.
Same? Who has
Same
filed?
Friday, they also on Friday.
You are again.
Lordship, in that case, we are not paying party. Lordship, Article 39.
Let us come to
Yes, yes,
39.
yes.
Yes, Mr. Hawk.
Discussion later in one of there, whatever melody is this.
Interim order you have. And affidavit filed.
Yes, madam.
But in 37, we have filed the affidavit and we have got the record also. The next item, my lord, I can file it by tomorrow, my lord.
What is this?
Same issue, my lord, cancellation of tender, my lord, after opening of the financial book.
Why the second petition?
The second is a different, second, my lord, first, my lord, he approached the honorable court because, my lord, it was not finalized. That was his impression.
Ah.
I furnished the instruction that in the meantime, it has been cancelled and fresh tender has been issued.
Which
So the
one?
second petition.
Oh,
So in the second petition, we have filed the affidavit citing the ground for cancellation.
this was withdrawn.
Yes, sir.
But I passed some order.
Yes, sir. But please, sir.
Made the
Yes, he is
correction to the
well,
schedule being admitted by the so we go to contract.
Satisfactory.
So you got this. Site visit certificate.
Side visit circular there, they have to file a technical evaluation was done.
Yeah.
The petitioner along with two others, bidders, they were technically qualified. But what happened, actually, there are two packages in the earlier DNA. They have already finalized settled letter acceptance was issued, work order issued, that work has already been under that is going on. In this case, in the again this package what happened, they did not open the
I remember
Yes.
long time back.
Yes,
They are not
they did not
opening.
open matter. Therefore, anyway, at the interference of Sonokura, they have opened the technical bid matter, and petitioner was qualified technically, technically qualified, along with two other bidders.
Then they withdrew.
Subsequent no, what happened, they did not do the tender till date, but they are not finalizing, that opening the finance bid. So I have approached the honorable court, during the pendency of the petition, the petitioner came to know that no finance bid has already been opened, whereas petitioner has been found as the L1 bidder, loyalty. Subsequently, I have filed the petition, challenging that no, there is another case, since I was the L1, so why my that tender is not finalized, during the pendency of the case, they have again retendered this case, they have cancelled and retendered, that cancellation, I have sent it.
Why are there two liquidations?
Yes, earlier, that was for opening the bid. Now, with this one, they have already cancelled, so, I have to find the.
But there is some interim order passed
Yes,
in
yes.
the earlier one.
Well, 948.
948.
Yes,
948 is the second one.
yes,
And the first one was?
well,
for not opening. For not opening. Now, the second one is for cancelling.
Cancel.
And where you are with the L1
Yes,
and they cancelled it.
they have cancelled.
Then what happens?
My lord, now, your lordship, my lord, they have said that, no, my lord, we have now required, my lord, CTSB, my lord.
Oh, that
ultimate
one.
promotional, my lord. In fact, I can say, my lord.
This is a new ploy of
Yes, yes, yes,
yeah. Now, wherever they don't like, they
Yes, they
ask
impose
for
that
condition. Huh?
only to facilitate those two.
I remember another
Yes,
matter is there, na?
Yes, my lord.
Where the other favorable contractors were there, they were lower bidder.
Yes, your passage case also,
And
my
you
lord.
did not get it because they withdrew, and then you filed another writ petition. Then I said that why don't you participate?
Because only these two contractors, my lord, they're having that qualification, my lord.
You do one thing. These are all under the government of Assam.
Yes, my lord.
Purely.
Yes, sir.
Central government is not involved.
No, my lord.
Another way is, yeah. Oh, yes. Ah. This is the same matter.
Yes,
Or there is another case where you withdrew.
yes, my lord.
That was closed, na?
Yes,
They
yes, sir.
wanted, they cancelled it and then they withdrew it.
Yes, yes, my
That
lord.
is another
Yes,
case.
another case. That is your passage.
Huh?
Your passage.
That is another favorite contractor of
Right,
yours.
right.
Zial Pasar.
Your passage.
Now you have got hold of another one, Deepak Sharma.
Ultimately, whatever, my lord, in the entire state of Assam, my lord, they did not, does not require any CTSB. Only while, my lord, the department, my lord,
Whenever Zial Pasar or Deepak Sharma becomes the lowest bidder, then they require that.
they impose that additional qualifications CTSB.
You got an interim order?
Yes,
Oh, very well. Affidavit filed.
yes, my lord.
Very well.
I have also responded.
You file reply.
Yes, my lord.
Okay. Let us have it after 1 year.
May I pray for around 27th of?
No. Let it be delayed. Interim order is there, na?
Yes, my lord.
Let it be delayed. Let it continue for 1 year, and thereafter, when it becomes difficult for the other two bidders to get it, then
My lord, in fact, my lord, the section 6 of the, my lord, Assam Procurement Act, my lord, it clearly imposes that you cannot impose such conditions, my lord, that can hamper the tendering process. This is totally inevitable condition, my lord.
anyways, let us have it sometime in the month of July.
That,
Anyways, these summer months you can't do anything. July.
Let it be next week, right?
No.
Ultimately, public work will suffer. So that way.
Public work is not going to suffer. Mr. Gugoi, you want to give it to these two contractors. Let them wait for some time. Anyways, you see, Mr. Hawk, if we pass an order also in your favor, holding that the cancellation is bad, and I'll ask him, then again they will do something. So therefore,
yes.
makes no sense. So let it be, by way of an interim order, we can stop them.
Interim is, my lord, against the new president.
So don't go ahead.
Yes, not to
Against the new one, did you participate?
No, ma'am.
Why? You don't have that city with me.
Because CTSB, my lord, except non-very entire notice in Assam, including the Assam, my lord, nowhere he required CTSB.
What is the CTSB? Let us also.
Cement treated surface, my lord.
Huh?
Cement treated surface, that is not.
Concrete one,
My lord,
in the flood affected part, my lord, that concrete is given.
Oh.
Complete.
my lord, what they're doing, my lord,
Only a portion of a, my lord, entire road.
my lord,
That is modified.
But that has to be
amount
complete.
yeah.
I remember. These areas, like certain areas are there.
Low-lying
In the
area.
Gauhati, Nagaon area also, there are certain areas there wherever there is a flood.
yes,
it
because,
happens. And I remember too.
my lord, while they prepare the PPR, my lord, they should keep in mind, my lord, these roads should be, before issuing tender, my lord, PPR is prepared, my lord, taking into accounts of all the things. PPR was prepared there, but tender was polluted, my lord. And while I became alone, my lord, oh no, he cannot be given this work. He needs it. So it was the CTSB. Now they need.
So you mean to say that today, if you withdraw from the bid process, or you withdraw the instant petition,
My lord.
or you say that, okay, I don't have, let me go out, then they will give it without CTS.
It is their intention. It is their intention, my lord. Clearly.
It is the new
Because
modus.
Till my lord, alone, financial bid was open, my lord. There was no requirement of CTSB, my lord. Well, finance bid was open, my lord, and I became alone, my lord. Now, my lord, next, yes. Because your lordship has already remembered, my lord, same thing happened, my lord. There are also this contractors are there. Other two contractors, my lord.
The same.
Yes,
I
same
remember.
contract. Yes.
When they come, they require the CTSB.
Yes. Government also so pleased with them, my lord. I don't know. Government also, my lord. Even lordship kindly see their have come through the individual base, my lord. It was required, my lord, recommended by the
So therefore, Mr. Ho, therefore, let us have it in the month of June, July, after the vacation. You see, I passing an order. I will pass an order. Then there will be an appeal in your favor. Then an appeal will be happen. The appeal will say that the order is wrong, taking into account they are the employer, they can do whatever I feel like. Then they say that, okay, the appeal and order also goes, then they will come up out there and they will look at whatever, maybe we are not going to have this contract, forget about it. We don't want, because we have not entered into the contract. There's no concluded contract, so why should I? So let us not have it. Then one fine day when you are not interested, then they will come up with this another tender, now CTSB.
Yeah.
So and then they'll give it to these two.
They are repeating this thing. Here, my lord, is not this method. Just I'm dating method.
There's no point. So let us have it in the month of July.
Here, but just I bought it in the method. I on the basis of my lord, on the basis of PQL, I letter number so and so from the honorable minister, please. The request of honorable minister, PhD, my lord.
PHC is requesting for in PWD.
Yes, my lord. So what is going on, man?
No, here the government speaks in one voice. Let's have it in the month of July. There's no urgency. Let them go to the division bench and let the division bench pass an order. Let the single judge hear it early. Why should the interim order is there? I think the interim order was passed on 23. No urgency. And when was the tender issued?
In February.
First tender was issued on 17/10/2025.
Yes.
So they could wait
Yes.
for not to open the tender for such a long time. What is the urgency for the court to decide this matter early?
Well, let me after 2 weeks in that case.
Why should I
Decided
travel?
sure that way, my lord. We'll give a grounds, my lord, for cancellation. So we will take a call on that.
Makes no sense. Okay.
In the meantime, the affidavit
We
I
can
will file.
issue a rule also.
That not in my lord this case.
Rule.
The public interest.
No, where is the public interest? Tell me. A contract was notice inviting tender was issued on 17/10/2025.
Yes.
You think of cancelling after 4 months.
Right.
That is why the second writ petition comes in. After 4 months, you come up for after more than 4 months, you come up. What is the urgency that this court should today hear your matter?
Well, let it
Yes,
be
when
after
there
2 weeks
is
or 3 weeks.
public interest involved, something else can be done. But otherwise, no.
No, ultimately, my lord, the public will suffer because we won the room. It's not what a government is for the public.
Then why did you wait from 17/10? When you don't have a particular project or go ahead without a DPR. You had a DPR.
Yes, yes.
And in the DPR,
It
there
has
was
been
no
modified
mention.
now, my lord.
There was no mention that this road will come within that particular
It
area.
was there. It was there.
So then why didn't you conclude it? And later on, after the opening of the financial bid, why did now you think
They
that this
say,
is
my lord, there's various public complaints, my lord, demands that this should be, my lord, constructed so that, my lord, during the
so
plant
this
time.
happened subsequently.
Yes, my lord. It's there in the note, my lord, why it has been rejected.
Let's see where in your reply.
In the affidavit, my lord.
Where?
Page 54, my lord.
Or even 51. So 51 and 54. These are the documents citing the reason.
Where the public complaints? So that they will have the cement treated subbase.
Yes,
It will be cemented.
only a particular portion.
Now you want, they would not be able to do.
Then you see the experience. Can do it. That is not an what I say, the scientific. That's not, can do it, but they did it, they impose a qualification. Who has experience of CTS.
But that is not on challenge. That clause, the experience part is not on a challenge. In the requisition. Though you challenge the NIT.
Yes.
On the ground that not be plotted by cancelling the earlier tender. But that particular clause in the new tender is not.
And how many years you require? 10 years.
Well,
How many years you require for the CTSP
that my lord,
as per the tender?
that my lord, I will check.
Where is the tender?
Only the NIT has been annexed. NIT will, that whatever was published, that notice is there. It is at page 35. 35.
But here it does not say about CTSB.
No, it will be there in the scope of work. It will be there in the scope of work.
So how does he know?
Now, he has not annexed the entire tender.
So how does he know that it's CTSB is there? They have enclosed the CTSB.
No, that ground is there in the ground for rejection.
So how many years of AI is required? Period.
That self life melody there that I can happen. The durability of that particular work.
And the area is somewhere where?
Yes, it is mentioned in the affidavit.
Where is the contract to be carried out?
In Albany,
district. Whatever, two packages.
Oh, that is why the Honorable Minister of
Yes,
PhD is
yes,
saying.
yes.
But Nolbari is his.
Yes.
But here is otherwise a public representative.
No, therefore,
constituency he
no,
can
no. Although they have used the manner as Honorable PhD Minister,
designation.
but actually he is interested taking into account that he is the MLA of the
Yes,
constituency.
yes.
So therefore, if it was in Jurhat, I would have thought about. But in Nalbari, if it is so, then obviously he may have an interest because he will be knowing it.
What I'm saying, another package, that is the normal town. It another what, that they did not need any CTS in another package.
You do one thing, let this matter remain for after 4-5 weeks. In the meantime, when I'm taking a bench 4, we'll get similar matters out there. Now we'll pull that matter and take it.
That part, that case is not there.
No, not there. Any other case we'll get it. Where CTSB is declared and
challenge is made.
like one order, one judgment I passed. What is the name of the case? They wanted to give it to one person who did not have any qualification. And he did not give certain documents also. But they were bent upon to do it. Then after that, when they were bent upon, then I got hold of another writ petition was filed by another. There, the PWD acted completely contrary to the earlier thing. Then I took up both the writ petitions together. And after that, I held that the cancellation was wrong, so and so. And as such, I said that, okay, you go ahead, but take a decision. Then also, then thereafter, I think an appeal has been filed to the state or something. Yeah, that is another thing. So this, let us wait for that, Mr. Hawk. Then Mahalakshmi. No, not Mahalakshmi. That is by this, like your client, Jiarka Prasad types, Rana Construction. Sure. When do you want it? Not so soon. No urgency.
End of May.
May, last week. Taking into account that the pleadings are complete, list this matter on 29th of May 2026. 28th. Can we have it on 28th?
Yes.
No, not 29th, 28th. 28th. 27 is close. 28th. It's Thursday. There is a chance of getting the matter. On 28th. So final disposal.
This matter may be tagged with the item 36, man.
90?
36.
36 is?
The Friday matter, man.
What is this Friday?
They also want Friday, man.
You want to file affidavit?
Yes.
Let us not take, because that is, has a history.
Same district, man.
The district is same, but the history is different.
Same history, Lord.
She has, you also have a problem with the Ansalik Panchayat. Do you have a problem with the Ansalik Panchayat or not?
The Gauhati Panchayat.
She doesn't have the problem with the Gauhati Panchayat.
Same month.
To file an additional affidavit about the claim that they are running a cattle market from the specific Patta land since December 2010. You have filed an additional affidavit. So that is a private dispute.
Yes.
Why should we look into it? Anyways, you want to file a affidavit?
Yes.
Mr. S. Dutta, appearing on behalf of the state PNRD, submits that he would like to file an affidavit. The PNRD department would like to file an affidavit. List this matter. When did I fix the earlier matter? 10/6, na?
Affidavit by
On 10/6/2026. Affidavit be filed on or before 1st of June 2026. Liberty given to the petitioner to file.
But in this case, I need some time, my lord. Instruction not yet received, my lord.
What is this?
Non-payment of bill, my lord.
It's a first date, okay.
Some time.
Mr. S. Dutta, the learned counsel appearing on behalf of the PNRD department submits that on account of the ensuing elections, he could not take the instructions. And on account of the elections to the Legislative Assembly, which took place on 9th of April 2026, he could not obtain the instruction and therefore 4 weeks time for filing reply. List the matter again on 15th of June 2026. In the meantime, the affidavit in opposition be filed on or before 8th of June 2026.
I never.
Mr. Hawk, where is he?
Here, before opening of the technical bid, it has been cancelled. So we have better case here now compared to the other. Before technical bid. And in fact, there was no interim granted. The tender process has been completed to my knowledge.
And the last day was You did not participate? Huh? In the second one? Huh? No. No, did you participate in the second one? Then what it means?
Well, it has cancelled, man. Cancelled on the, technical ground. Subsequent, man, they say some work order has been issued, man. I don't know, man. They are sub file effectively.
No, I'm not on. You participate in the first round.
Yes.
Did you participate in the second round?
No, man.
Right, you have, Mr. Hawk. Yeah. Filing this type of late petitions make the people think that you are not serious. Mr. Hawk, what right you have here? You participated out there, they cancelled it, they have the prerogative to cancel it.
My lord, they did not communicate the reason, man.
What?
They did not communicate the reason of cancellation.
What right you had? Was your technical bit considered? No. Then they can very well cancel it whenever feel like. But once there is something out there that this particular contract was being awarded out there in a particular manner and you are the L1 or something to the effect, just to deprive you, they have cancelled, which they have done in the case of Deepak Sharma. Something like that, okay, you have a case. But not this type of case. And we dismiss with cost. Cost, na? 10,000.
Here,
There's no case, Mr. No
Minor
case. So you are filing a case for it.
what I want to happen to that.
You do one thing, you initiated the second contract.
My lord, to my knowledge, my lord, tender has been concluded. In fact, work order has been issued. Telephonically, I have got the information.
Well, let us see the notice inviting tender, the second one. 18 months, na?
Yes.
We have this matter after 18 months. After 18 months. This type of petition, 18 months. You don't have a case. One can say. Yes, you have a good case, it's a different thing. We dismiss it. Heard Mr. S. Hawk, the learned counsel appearing on behalf of the petition. Mr. B. Gogoi, the learned additional advocate general Assam, who appears on behalf of the PWD department. The petitioner herein have assailed the cancellation notice dated 30/12/2025, whereby the notice inviting tender, notice inviting tender bearing DNIT number CE/DEV/TB/116/2025-26/14 dated 14/11/2025 issued for the work for improvement and upgradation of road from Dwarbon Bazar at Silchar. There's Hailakandi Road to Belaipur via Lower Bond FB brackets C dot H dot 0.00 kilometers to CH dot 10.00 kilometers and the Assam Mala 3.0 for the year 2025-26 was cancelled. The ground on which the instant petition is based is that the petitioner had participated in the said notice inviting tender, which was issued on 14/11/2025. Full stop. It is an admitted fact that the technical bids in respect to the said notice inviting tender dated 14/11/2025 was not opened, and it is an admitted fact that prior to opening of the technical bids in respect to the notice inviting tender dated 14/11/2025, the said tender was cancelled.
actually, my lord, they have the date fixed, my lord, for opening the tender, my lord, but they did not open the tender.
Prior to opening was cancelled. Full stop. Under such circumstances, this court does not find that there was any right which had accrued upon the petitioner on the basis of mere participation in the said notice inviting tender. Full stop. Consequently, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed with cost.
No, my lord.
But Mr. Hawk, that matter, we should have it after 2 years.
Right.
Yes, what is this, Mr. Hawk?
Payment of contractual use of the procedural.
How much?
That's matter 2,84,490.
PWD Finance AG. They are there. Okay. Disposed as per Tamsir Ali.
Verification and payment. Verification and payment.
Verification and payment as per Tamsir Ali. Verification within 1 month, payment as per Tamsir Ali.
Please, Your Lord. Sir, this is a petition where we will say the process of appointment of receivers. And there is additional ground, my lord, where I was prevented from selling my freehold land even before the attachment proceedings were initiated. Now, there are two grounds of challenge in said petition. And my lord, on the last date, liberty was granted to us to file additional pleadings.
Huh?
On the last occasion, my lord, there was an order passed in which this honorable court was pleased to give us liberty to file additional pleadings so far as the freehold land is concerned. And my lord, day before yesterday, we received one notification which was issued from the co-district commissioner annexing the report of the circle officer.
Did you file the additional affidavit?
No, my lord, that is the difficulty, my lord, because my lord, the receiver has already been appointed now. Now, therefore, a third party right has been created. And we want to file an IA, wanted to file an IA, but the petitioner herein is not suffering with good health. So, my lord, 1 day time may be granted to us. He was supposed to come this week, but could not because of his ill health. Now, we want to file an IA for impleadment of party of the private respondent who has been appointed as a receiver now. And in addition to that, my lord, we have a document now which we were pursuing because of the ensuing election, my lord. We were not getting those
How
documents.
much time you require?
1 day time, my lord. We will file tomorrow, my lord. Day after tomorrow, my lord can.
Absolutely no. You were directed to file additional affidavit as on 12/3/2026. You have not filed one.
Because of the elections, my lord, we did
Election,
not get
no
all of
elections,
the documents, my lord, from the land revenue department, my lord. Circle office. my
Mr.
lord.
Esdas, appearing on behalf of the petitioner, submits that he requires some time to file an interlocutory application to implead the receiver.
My lord.
In addition to that, further time is sought for on account of to file the additional affidavit, the leave of which was granted by this court by the order dated 12/3/2026. List this matter on
Next week,
18th
my
of
lord.
May 2026. In the meantime, the petitioner would be at liberty to file the necessary additional.
But so far as the receiver is concerned, my lord, one line, my lord, the details of the receiver may be furnished to us along with the agreement which they
You
have
have appointed, no?
entered upon.
Yes.
Agreement
The
and
council,
details of-
Mr. So he appears on behalf of the
Respondent number 2 to 5.
2 to 5 is directed to provide within 7 days the details of the agreement which have been entered into with the receiver as well as also provide a copy of the said agreement to the counsel for the petition.
I appear for the forest department. We have received the instruction, my lord, we would like to place it.
Huh?
on record. We would like to place our instructions on record, my lord. Some bulky instructions have come, so my lord.
In the
And
Mr. Ibotakur, appearing on behalf of the Forest Department, submits that he has received the instructions and would be filing an affidavit. How long?
2 weeks.
In that regard, 2 weeks' time for filing the affidavit. This court have also taken note of that there is a interim direction passed by an order dated 23/3/2026. Accordingly, list this matter again on 22nd of May 2026. In the meantime, the respondent Forest Department would be at liberty to bring on record its stand by filing the affidavit on or before 18th of May 2026. The interim order passed earlier shall continue till the next year.
Much so.
Get up. 54.
Today is the returnable date. Lordship, we have already filed affidavit. Today filed.
You have filed affidavit?
Yes, Lordship, today filed.
Mr. Ekolita, the learned counsel appearing on behalf of the IOCL,
All India Limited.
All India Limited, submits that the affidavit has been filed on behalf of Indian Oil Limited today. The said affidavit, however, is not on record. Ms. So-and-so, appearing on behalf of the petitioner, submits that the said that they would like to file a reply to the said affidavit. And accordingly, 6 for how much? 2 weeks? 2 weeks' time. List this matter again on 25/2026. In the meantime, the affidavit in reply be filed. The registry shall bring on record the affidavit in opposition filed by the respondent numbers.
Only,
the respondents.
Thank you.